But I'm ready to file the review manual without certified copy of the server copy.
What do you want to file? Review application.
With the server copy, my lord, praying leave to file a review with it.
What? Review application?
Yes.
Why without server copy?
My lord, I have applied for the certified copy, my lord. It is taking long time, my lord.
It's taking long time. What is the date of order?
Date of order, my lord, 20th August 2020.
August. Then it should be there.
My lord, but it has not been made available.
You applied late.
No, I have applied, my lord.
You applied.
Yes.
Today is not the leave granted. Yes.
But with regard to item number 139, second appeal matter, yesterday I mentioned
Yes.
for fixing of a date, Lord. Lord, written arguments have been filed from both ends. Very short
Wait
matter.
for the appellant.
Someone is appeal and I will inform him.
Mr. Razi Bhattacharya.
In this matter,
Mr. Razi Bhattacharya,
take the mic. I cannot hear you.
I'm led by Mr. Razi Bhattacharya.
Yes.
His family members expired today. So
Okay.
I'm praying for not today.
No, it may be not today, no issue.
139.
Planet Council asks for fixing a date for hearing.
আজকে
139.
139.
Sorry, my lord, sorry.
Lord, since the written arguments have been filed from both ends, it was heard. And it will take not more than half an hour. Only the point and later ready executed the deed according to the appellant. The appellant executed deed after accepting the consideration sum before the register, and thereafter file a case for cancellation of the deed. It was obtained by misleading her. This is the
case all about.
Yes.
This is the case all about.
Yes. But written arguments.
Now, why in the second appeal? What is the order of the learned court below?
I succeeded in the appeal.
Okay.
The plaintiff preferred the second appeal.
Decreed, thereafter reversal,
Then
the second appeal.
Okay.
I understand.
But very short matter. It will not take more time. Written arguments have always been filed from both ends. Only to see the judgment and a lordship can decide it.
Now, today it is fixed. Okay. Today it is already listed. That's why I can be take up today also. If it reached.
Yes.
If it was not reached,
then next week, Lord.
Next week it will appear.
Next week.
Yes, next Friday it will be appear.
No,
All Friday it will appear.
It will be appearing every day, every week. So also kindly fix a date so that I will inform the other side and it may be taken up on that date, Lord. It will not take much time, Lord.
No, I understand. Let me see how far we can go in the list. Otherwise, at the time of rising, I shall pass the order for listing. And I can say you that I have only 1 week. 13th is the date. Next week. Thereafter, it will be
on 13th may be fixed. So that I can give the notice.
Let
it be primary fixed on 13th.
No, 13th I cannot fix now. What? Let me see. Today it can be heard. Today also it can be heard.
I think not. It may not reach today.
No, I see that both the matters, the adjournments are taken.
Then I shall take the chance.
Yes, that is the issue I am saying. You just.
Very well. I will be taking a chance. If it is not, then before rising, I shall mention.
Before rising, you just mention it.
Okay.
Okay. Please take call.
I was mentioning item 110 of this list.
110.
Well, this is I'm for the appellant. This is very old matter. I'll take instruction for and come back.
Let me call the matter. 120 is the second application, second matter. I'll call it.
I'll do one indulgence, Lordship. Last Tuesday, Lordship was kind enough to hear out one matter that the HON'BLE is also appearing. On that particular date, he was not here, madam. 10th is fixed for the next date. But 10th, I have a serious predicament. I have effected service upon the respective parties. My lord, instead of Tuesday, my lord, it may be Wednesday. I have
how today I can assess.
No, just I am mentioning it because of I have served notice upon the other side that today I intend to mention before the Honorable Court. My lord, on Tuesday.
Mentioning is on Monday only.
Yes, my lord. On Tuesday itself, we will pray for adjournment. Lordship, prior
You
to that, I
can
have
pray
just-
for adjournment,
Yes.
I will adjourn it, no issue.
I have circulated later, my lord.
Okay.
Lordship,
A matter relating to the petrol pump, my lord, under the new motion heading. Today,
Today, no mentioning. Come on Monday.
I have served the copy upon the.
No mentioning.
be permitted, Lordship, as per your direction, Lordship, the second appeal is to be come today,
Yes,
December, but it's not.
you mentioned it.
Yes, Lordship, I will mentioning in 11 November, and as per your direction, Lordship, you said this will be appear in the.
What is the number of the second appeal?
Hmm.
Perhaps record is not there. That's why it was not listed. Otherwise, it would be always listed. Record is not there. Record is not there. That's why it is not taken. Otherwise, all listed will be there. No exception.
Given me another date after as per your.
No other date. When it will be available, it would be listed. No issue. Only just finding the record is requirement. These are old records, you know. It has to be arranged. Otherwise, they cannot send before me. He has to arrange the LCR, everything. Otherwise, I will call them. Yes, that's why they are causing delay to sending the records, because they cannot assemble all the papers. Without sending papers, they would be otherwise. Okay, so let them arrange. Let them say. Otherwise, your list is there. When it will reach, I will list it. Okay, call the list.
Lord, I am for the respondents,
Yes.
WBPTCL.
By Mr. Rajiv Bhattacharya, his family member got expired today morning.
Okay, what is the application?
Well, the application has not been served, but I understand that one name has to be deleted due to death. On last occasion, I had a talk with Mr. Rajiv Bhattacharya. Maybe for deletion of one names.
Recording the death of plaintiff.
Yes.
Amita Biswas.
And he should be deleted from the, that was there.
Substitution application. No.
No, not substitution. He should be not omitted the name of the dead persons. Other respondents are there.
Other respondents already on the record.
Already on the record, as I understand, had with Mr. Rajiv Bhattacharya, Rajdeep. তাই তো একজনের নাম মিট করার জন্য That is exactly said by Rajdeep on last occasions. I have heard from him. But from the prayer, it can be, Your Lordship.
Where is the memo? Now, doesn't.
কি হবে?
Dispute with regard to installation of electric pole. It's a very short matter.
So today I am disposing of the application. Okay. What is your instruction? This is your application.
ওইটাই omit করেছিল ওটা। That is the application. Name omit করবে। এটা নিয়ে
Please take down. Can 10 of 2024. This is an application for appropriate order.
Madam, may I take back your lordship?
Yes. It appears that during pendency of the appeal, respondent number 1A, Amita Biswas, has expired, leaving behind her sons being respondent number 1B to 1D. The deceased respondent number 1A left no other legal heirs. All legal heirs are already on the record. Considering the situation, it appears to me that the can 10 of 2024 being true and bona fide, being true and bona fide is required to be disposed of. Next, accordingly, can 10 of 2024 is disposed of with a direction that the name of deceased respondent number 1A be deleted from the cause title of the memo of the appeal. Full stop. The department to do the necessary correction within a fortnight from date. Can 10 of 2024 is disposed of. Let the matter go out of the list. Parties are at liberty to mention. Next.
Well, I'm for the appeal. Well,
Yes.
This is an old appeal. Well, I'm not in touch with my client. Can we make it after vacation? I'll inform them there.
Why it is appearing under the heading of application? What is the application?
That also I do not know.
Who mentioned it?
I did not mention.
You did not mention it.
No, I don't.
Application for stay. This is the can of 2001. এটা কে মেনশন করেছে? কে মেনশন করেছে? মেনশনিং স্লিপ কোথায়? ঠিক তো? কে মেনশন করেছে? লিখে নি। রেসপন্ডেন্ট অ্যাপিলেন্ট লিখে নেবেন। একদম নেবেন না, না নিলে।
Lordship, I'm ready.
You have mentioned it. Are you appearing in this matter?
Yes, I'm led by Mr. Shonak Bhattacharya.
Okay. So, who filed the application? Can
I filed the application.
You can stay
Yes,
application.
Yes. Well, can you give me some time because I'm not in charge with my client. So let it be after vacation.
Once the application is pending, your lordship, that
2002.
2002, she can 6449 of 2002.
বলুন
কি করবেন?
6449 of 2002. This is the can.
6449 of 2000.
Stay application is pending since 2001. What is the purpose of filing the case stay?
Stay was perhaps granted, my lord. That's why, my lord, they have kept it silent. Now, my lord, what happened, my lord? My client, my lord, being the respondent, my lord, all are very aged. Now, my lord, I would be, my lord, praying for expeditious hearing of the appeal itself.
Okay. Then it would be appear after vacation,
Lordship,
10th of January,
Lordship,
under the heading of hearing of appeal.
Lordship.
Hearing of appeal, my lord, the applications are pending. It can't appear.
All the application would be taken up along with the appeal.
10th of January.
My lord, there are, my lord, so many cans, my lord, none of them served upon us.
All will be disposed of along with the hearing.
Yes, kindly, in the meantime, kindly
Yes, yes.
direct the petitioner to serve the copy of the applications upon us.
I will.
Okay, you serve all the copies.
Lordship.
My lord, in the meantime, my lord, department may be directed to give a, my lord, report whether LCR has come and, my lord, whether paper book is ready or not.
2002 appeal LCR is not reached.
My lord, that the appellant may be,
LCR is checked. LCR has not reached.
then, my lord, the stay order of stay has to be vacated. I cannot, my lord, suffer for eternity, my lord, because they have not taken steps. Kindly vacate this order of stay then.
And on 10th of January, can you fix it? And on that day, can you hear about the application?
Well, there is no order of stay, I think. Two 2002, there is an order of stay for 2 weeks after vacation. Till 2 weeks after vacation.
Thereafter,
Thereafter, it was not
no,
extended.
not extended. Very well.
Not extended, not mentioned, nothing has been done. Very well. Please take down.
এটা কোনটা?
Instant second appeal is pending since 2002. Full stop. The
পরেরটাই? মেমোটা দাও তো।
respondent mentioned this matter. Full stop. This matter appears under the heading of application. It appears that an application for stay is pending, being can number 6449 of 2002. এটা can number 2 করো আর 6449 টা ব্র্যাকেটে করে দাও। Can number 2 of 2002. Full stop. Learned advocate appearing on behalf of the respondent submits that the instant appeal may be heard expeditiously as the respondents are very aged persons. It further appears that the LCR has not reached. Concerning the submissions, let the matter be fixed on 10th of January 2024 for hearing of the appeal along with all pending can applications. Full stop. The learned advocate for the appellant is directed to serve the copy of all can applications to the respondent within a fortnight. Full stop. The department is directed to call for the LCR immediately from the office of the learned trial court.
My learned friend should
Learned
put
first appellate court.
special messenger cost for that.
Who shall put the special messenger cost?
Appellant?
You cannot put pressure upon the appellant like that. Okay,
But from
let the
2000.
department do this.
Very good. Kindly.
Thereafter, I'll take up this course. No issue, just wait. কি বললাম বল? Code, full stop. The department is directed, and the department is department to ensure that the LCR be reached to this court on the returnable date. Reached and placed before this court on the returnable date.
Paper book, Milord. Paper book is also not prepared.
Paper book not ready?
No. Correction.
LCR is paper.
But this matter was mentioned without service of me.
What was he doing from 2002 to 2024?
Okay, let the LCR become.
Well, the paper book, Milord, in the meantime, let him prepare the paper book.
Do you have the copies, papers?
Well, I do not
No,
have
this
anything
is
right now.
Milord, this
The
is
matter
Milord
has
second
been
appeal.
mentioned-
Only
the
Milord
matter
took
has
up
been
it. This is
mentioned
not first appeal.
Without any notice of.
Yes, yes.
appeal.
Even if notice was given, he would not have prepared. Milord, let him prepare in the meantime. He has all documents.
Okay. The appellant is directed to prepare the paper book and place the same with the department according to the law. Next.
Milord, I am for the appellant petitioner. There are two applications. One is CAN 10497 of 2003.
What are the applications?
One, Milord, first application, Milord, the sole respondent had expired. That is CAN, Milord, 10497. Second take Milord.
Where is the can?
Milord, it was filed, Milord, must be record.
10497.
Yes, 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 yes.
It's the old can.
Yes, Milord.
2003 can. Now you are mentioning
Milord,
2024.
Milord, yes, Milord. In paragraph 6, Milord, I have given the particulars filed within time. Paragraph 6, Milord.
And what about other respondents?
Yes, other respondent, sole respondent had expired. Now, Milord, one CAN 2, Milord, has been filed. Milord, for Milord, heir of this one of the sole respondent had also expired. First, Milord, 10497 has to be allowed.
And thereafter?
CAN 2, that is Milord recently filed, Milord. Kindly see, Milord, page 3, para 6 of the application. Kindly see, Milord, your petitioner states that during pendency of the instant appeal, sole respondent opposite party herein Sri Shambhu Prasad died intestate on 4th of October 2003, leaving behind him on surviving mother, wife and two sons, namely Rina Prasad, Sudama Devi, Abhishek Prasad and Abhijit Prasad.
Yes.
Now, Milord, these had to be substituted. Now, Milord, in CAN 2, Milord, this Sudama Devi has also died.
No. You are submitting otherwise.
No.
The substitute application has been already allowed in the 2004.
Very well. Then, Milord, CAN 2 has to be allowed now. Then, Milord, CAN 2.
Take proper instruction.
Yes. Not that order was not. 2002 এর order. Then, Milord, CAN 2, Milord, has to be allowed now. Sudama Devi, Milord, has expired. His heirs already on record.
CAN 2 koi? CAN 2 কোথায়? একটাই তো CAN পেয়েছি। হ্যাঁ? এটা CAN 1. No, no. কত নম্বর এটা আছে এটা? 111। তাহলে ক্যান টু কোথায়? ক্যান টু কোথায়? হ্যাঁ, different answer.
হচ্ছে তো 14 থেকে তার আগে কি 13 থেকে
Can two has not reached to the court.
Milord, I have an extra copy, Milord, it may be.
Have you served?
Milord, Milord, upon whom, Milord, unless, Milord, substitution is allowed, Milord, I cannot.
Substitution is already allowed.
No, now, Milord, another respondent has allowed. Milord, one of the substituted heirs has, Milord, expired.
Then you serve other respondents.
Very well, very well.
Without serving, how can I take up
Very
the
well,
matter?
very well. Kindly passes that order, Milord, I will serve.
Please take down. Can 1 of 2003 within bracket old can 102 sorry 10497 of 2003 has already been disposed of. Heading করে দেবে এই can 1 and can 2. Can 1 of 2023, can 2 of 2021. আছে?
স্টেটাস কো অর্ডার দিয়েছে তার কি ইমপ্লিমেন্টেশন হবে গো বিবেক চৌধুরী অর্ডারটা দেন ওনার টিম হবে
Can 2 of 2021 has not reached to this court. Learned counsel for the no appellant is directed to serve the can 2 upon the surviving respondents. Let the matter appear in the list and no surviving respondent and file an affidavit of service on the returnable date. Let the matter appear in the list on 3rd of January under the heading of application. 3rd of January.
May I take back that copy, Milord?
Yes. কোনটা দিয়ে দিই আরে ক্যানটা দিয়ে দিই
আনিয়ে নেবেন এটা।
next
Well, I'm for the respondent opposite party number 1 by
let them call. What is the application pending?
application for injunction. They are praying after 12 years. My lord, I am filing the affidavit in opposition. My lord, I am serving them. Fine.
Can 3.
Yes, my lord. Can 3.
Yes.
Can you see paragraph 10?
Paragraph 10.
And is opposition paragraph 7.
Yes.
Therefore, your lordship will grant it. No denial.
What is your prima facie case here?
He has started making construction.
What is your,
Changing the
who are you?
nature character.
My lord, there was
I'm the
Let
plaintiff.
me hear the
Fine, fine.
party. Why you are such a way?
I am the plaintiff appellant
You are the plaintiff appellant. You have filed the suit for what?
for declaration of title and recovery of possession from the defendant, the enclosed portion. Trial court declared the suit.
Declared the suit.
Appeal court reversed.
Yes.
Against that, Lord, you filed the second appeal. Appeal has been admitted on the following framing substantial question.
Is there any stay in the second appellate court?
No, there is no scope.
No scope of stay.
But
So they are,
on 29th of October 2024, he has tried charging to change the nature and character of the property. That is why I have to file the application for injunction. In that paragraph 10, no denial.
what nature and character they want to change?
That I have stated paragraph 10, and I've given the photograph. Page 12, your lordship will get the photograph. Page 12, 13.
Yes.
So you have seen paragraph 10 and the photograph of my application. No denial to that. During the pendency of the appeal, if he changes the nature and character of the property,
What nature and character they have changed?
that I have stated paragraph 10 of my application,
Yes.
they are filling art, they are making a new construction. They are going to make a new construction. And for that, Lord, I have given the photograph page 12 and 30 of my petition.
They making construction over which property?
The enclosed portion,
Encroached portion, which is under their possession.
yes.
Admittedly under their possession. Yes.
my lord, kindly sees my paragraph number 7, my lord. There is a specific, I oppose the paragraph number 10. And my lord, if your lordship kindly sees the photograph, it is not the new construction. There was a construction, there was a shop room, and that will be reconstructed. Renovation, mere renovation. A poor person renovating the shop portion by some temporary measure. And my lord, it is in my favor. It is in my possession. I am holding the business. I am carrying the business in the property. And after 12 years, when paper book is ready, my lord, no new nature, character, nothing has been changed. It is in my possession. I am continuing in this business, in this property, my lord. After 12 years, they are saying I am changing the nature and character. I'm doing the business. Kindly see from the top to bottom the picture, my lord. The photograph which has been annexed by my lord, senior my lord. Kindly see, my lord. It is a new construction, my lord.
Okay, hard. Anything?
My lord, that's
Please take down. Can 3 of 2024. Affidavit in opposition by the respondent number 1 against Can 3 of 2024 is taken on record. Next, brother. This is an application for injunction against opposite party stroke respondent number 1 for restraining him from changing nature and character of the property in dispute. Full stop. Learned counsel for the appellant petitioner submits that during the pendency of the appeal, suddenly on 29th October 2024, opposite party stroke respondent number 1 and his main and agents started to change the nature and character of the property in dispute by filling the land with earth and by demolishing the existing structure standing thereon, as well as by making a new construction over there. Full stop. As the it is the submission of the learned counsel for the appellant that as the petitioner trying to change the nature and character of the disputed property, so it is necessary to pass an order of injunction so that the nature and character of the suit property may be maintained. Full stop. Learned counsel appearing on behalf of the respondent submits that the petitioner appellant suddenly appeared before this court after 12 years of admission of the appeal with a prayer for injunction. Full stop. He submits that the opposite party number 1 was all along possession over the property and he is carrying on the shop room. The opposite party number 1 only trying to renovate his shop room. No nature and character of the land would be changed. So at this juncture, the injunction is not required. Heard the learned advocate for the parties. It appears that the next paragraph, plaintiff has filed a suit for declaration and recovery of khas possession in respect of plot number 469 under Khatian number 273 under Mauja Sihipada PS Purvastholi. Full stop. It is the case of the plaintiff stroke appellant that the defendant stroke respondent is unlawful occupier of some portion of the disputed plot and running a hair cutting saloon thereon. Full stop. The plaintiff filed a suit for recovery of possession from the defendant. Full stop. The learned trial court has decreed the suit. In appeal, it has reversed, against which the second appeal has been preferred. Admittedly, there is no order of stay in the second appeal. Full stop. It is the admitted fact in the entire suit that defendant stroke respondent is in possession over the suit over the portion of the disputed property and running a saloon. Whatever may be the nature of the saloon, the nature of the building purchased by the defendant, if plaintiff stroke appellant succeeds, the same would be demolished and the plaintiff would be entitled to recover the same. At this juncture, as the defendant was all along possessed the portion of the disputed property, I find no justification to pass an order of injunction. Under the above observation, the application being CAN 3 of 2024 is dismissed and disposed of. Full stop. Next para. It appears that the appeal is otherwise ready for hearing. LCR has reached. Paper book has already been placed with the record, placed with the department. Let the matter appear in the list under the heading of hearing on 17th of January.
Grateful. Sir. Grateful.
Next.
On the 13 my lord, I am appearing for the appellant petitioner. There is some notice of service. This service intimating the matter will be mentioned before your lordship. But the London advocate who used to appear in this matter, Mr. Priyabrata Ghosh, and after that he has expired after COVID 2023. So I need a direction from your lordship serve directly upon, because I have sent notice to the party, the respondent directly. So
you have served upon the respondent directly.
Intimating the matter will be mentioned before your lordship for inclusion in the list. But there is no representation from the respondent. So for avoiding all complication, my lord, may I serve allowing this application to the other side?
Yes, yes. You served again.
Yes, yes. That's why, my lord,
yes.
Because was
what is the application about?
This is, my lord, the suit for eviction regarding.
Now, what is your application?
For
Order 20 Rule 10.
Rule 10. My lord, during the lifetime of the appellant, he transferred the property in favor of this person. So they want to substitute, in effect, substitution, because he died, the original appellant. So should be stepped into the shoes of the appellant. This is the application file.
This should be made a party in this proceeding.
And with the leave of the court, he can proceed with the appeal.
Please take down. CAN 2 of 2023. This is an application under Order 20 Rule 10 CPC filed by the appellant. Learned counsel appearing on behalf of the appellant with his usual fairness submits that he could not, though he served the application upon the respondent, but
no, I have served the notice indicating the matter will be mentioned before your lordship for inclusion.
Serve the notice upon the respondent that the matter shall appear in the list under the heading of application. None, full stop, none appears on behalf of the respondent. Considering the situation, the petitioner is directed to serve the application upon the respondent directly through a register post and file an affidavit of service before this court on the returnable date. Let the matter appear in the list under the same heading on 3rd of January.
পাঁচ মারা গেছে 5, 7, 11 কত মারা গেছে 4 মারা গেছে আমার চিঠি
Yes.
Now, my lord, I had filed application, my lord, can 5, my lord, for appropriate order. My lord, there was an order of injunction, my lord, which was prevailing in the order, appeal, my lord, which was made absolute also. Now, my lord, what happened, my lord, the respondents, my lord, they are, my lord, continuously, my lord, cutting down the trees, they are changing the nature and character of the suit property. Now, my lord, that's why, my lord, this application has been filed, my lord, for implementation of the order of injunction through police help. Now, my lord, what happened after filing of the application? My client has come to know, my lord, respondent number 5 and 7, my lord, had expired.
5 and 7 expired. So you have to take proper steps upon them.
Yes, my lord. In the meantime,
And it is a report of the Lojima court that you have not taken filed fresh requisites upon respondent number 2D 6, 8, 9, 14, as well as the 5, 7, 11, and 13.
5, 7, my lord, 11.
5, 7 has expired.
5, 7, and
So you
11.
take steps.
I will definitely.
Okay. Please take down.
Cannot.
It is reported that the appellant could not take proper steps upon the respondents. Full stop. Learned counsel appearing for the appellant submits that during the pendency of the instant appeal, some of the respondents has expired. So he has to take steps regarding substitution of the said respondents. Considering the situation, the matter be adjourned today. No, considering the situation, the matter be released. No, so matter will go out of the list. The appellant is at liberty to mention the matter after compliance, after due compliance.
May I once look at the report?
Yes.
লিখে নাও নোট করে নাও কার কার
Next.
My lord, in this matter, my lord, I am for the plaintiff respondent, my lord. Both advocate of both side died, my lord. This is a 68 matter, my lord, and as well as my
You
lord.
mention this.
My lord, I have mentioned, my lord, two plaintiff alive. My lord, my humble submission before your lordship, my lord, kindly direct to administrative notice, my lord. Dependent are 22 dependents, my lord. I have mentioned, my lord. 68 matters.
What is your name, sir?
My name, my lord.
Yes.
My name, I am Sukanta Das, my lord. I have a vocal nama with for my lord Ashok Kumar Pine and Ardhendu Kumar Pani, my lord. Ashok Pani and Ardhendu Kumar Pani, my lord.
Respondents.
Here respondent.
Respondents number.
My lord, I do not know, my lord. That's why.
What
No
is your-
document.
Yes. What is your name?
My name is Sukanta Das. Along with my lord, Senasis Jana, my lord.
Learned counsel Sukanta Das with Snehasis Jana
Yes, my lord.
appears on behalf of some of the respondents and submits that this is an old appeal pending in 1968. Full stop. The advocate on record on behalf of the parties has already been expired. It is not his knowledge whether the other parties are alive or not. Considering the submission of the parties and considering the report filed on behalf of the department.
ভালো করে লিখি গোটা গোটা অশোক কুমার
It is required to serve an administrative notice upon all the parties. Full stop. Accordingly, the department is directed to serve the administrative notice upon all the parties except respondent number.
I have
Ashok Kumar Pani and
Except respondent, namely Ashok Kumar Pani and
Ardhendu Kumar Pani.
Ardhendu Kumar Pani. Full stop. The department is directed to submit a report of such service of administrative notice on the returnable date. Let the matter appear in the list on 24th of January
24
under the same heading.
24 January 25
Department যাবে
4
or একটা department
24 January 25.
Next.
This matter, my lord, I am appearing for the plaintiff appellant.
but I appear for the respondent numbers. My lord, I appear for the respondent numbers. Here.
Four and five.
4 and 5. 4 and 5. Thank you.
Last occasion, my lord, it is appearing for my lord, just because when his lordship was pleased to direct us to supply the copy of the substantial law as framed. The copy was also served to my learned friend.
Sir.
Subject to question, my lord, so there.
Substantial question of law.
Yes, my lord.
It was framed at the time of
Hearing of the appeal, admission of the appeal will be heard on the grounds. It was mentioned. Subsequently, my lord, after the hearing, the honorable court was pleased to find this will be the substantial question of by recasting the same. Subject to question, my learned friend can electronic page.
Page.
May I hand over?
yes.
But I have received.
It is my copy will be stored. It was my copy, my copy was might be in the report. এই যে আমাকে দে
আমি নিজেই করছি
এই করছিস
আর দিয়েছো তো দেখি দেখছি কোথায় আছে
মাস্কাটা পেয়েছিস
কিন্তু 2 কোটি হেরে গেছে
হ্যাঁ পেয়েছি এই করে জিতবো বলেই তো মামলা করছি
Yes, what is the suit about?
Well, a suit for declaration and injunction.
Yes.
I'm giving only the brief outline, and after that matter, so the plaintiff and the judge Mr. Concerned. The original property belongs to a Nirav Borni Dashi. Defendant number 1. Defendant number 1 executed deed of gift in favor of Shambhunath Sarkar, who is the defendant number 2. That was duly registered on 16 to 1966. Now, my defendant number being the absolute owner executed a sale deed in favor of Jagannath, the plaintiff on 2nd 12/1966. Can you record these 2 dates?
Yes.
The deed was ultimately registered under the direction of the legislature under section 73. That is on 13/6/1967.
Yes.
Now a suit was filed collusively between defendant number 1 and defendant number 2 for declaration that the deed of gift is valid in the eye of law and also for consequential relief.
Deed of gift is
Valid in the eye of law. It is a defendant number 1 and 2. Who defendant number 1 already transferred executed the deed in favor of B, which is subject matter of execution in terms of section 73 of the pursuant to the order of the district register. After that, my lord, a suit was filed between defendant number 1 and 2 for declaration that the defendant number 2 by virtue of a deed of gift became the owner of the property. That suit was treated in Solnama between defendant number 1 and 2, where I am not the party. Now I filed a suit based on my deed
of sale.
Deed of sale, which is executed, and both the courts below held that as the registration was made subsequent to the filing of the suit, a registration was made subsequent to the filing of the suit. Therefore, you are not the necessary party at that suit, and that degree is binding upon me. May I clear to your lordship?
Yes.
But
So initially the suit was filed for the declaration that the deed of gift, between defendant number 1 and 2 to be declared void.
No,
it was decreed.
The declaration sought for that by virtue of the deed, defendant number 2 became the owner of the property.
Defendant number 1 of the property.
Against the defendant number 1. This suit was filed. In the meantime, the deed was executed in favor of B, which has not been registered. Subsequently, pursuant to the order passed by the district register, same got registered. In the meantime, what happened? By virtue of that, in that suit, a sole number degree was obtained by between defendant number.
What is your suit here?
My suit is not declaration of my title and injunction, where I made both them as a party, and I am claiming through the strength of the deed. Now, one of the question arose.
Sir, is there any prayer regarding the deed of gift?
Yes. Those are there. Now, question cropped up whether the suit filed after passing of the order under section 75, but the execution is prior to their deed, whether section 43 will apply to the date of execution. If the date of execution comes, then what are the subsequent deed of?
So what is the title suit? What is the decree?
Title interest in favor of defendant number 2.
No. What
In
is
my suit.
Fet.
Dismissed by holding.
Dismissed.
Yes, both the court.
By holding.
That the degree is binding upon me.
Decree is binding upon you. Okay.
But I am not the party. In the other suit.
In the other suit. This is the this is
the,
okay. So what is the substantial question of law you are trying to agitate in this?
একটা কবি এটা রেকর্ড সব জজ সাহেবের একটু তাহলে দেখে বার করতে পারি জজ সাহেবকে দেওয়া হচ্ছে অন্য কোর্টে দেওয়া হয়েছিল বলে আগে রেকর্ড তো থাকার কথা রেকর্ড তো দেবেন অর্ডার বুকটা দিন ওর মধ্যে আছে may I go through the order book because on the earlier occasion it was handed over to
the court.
Yes. That's why, my lord, I want to check it up of the order record book whether it is there or not. Single page might be just in the meantime. Thanks.
No. It is not here. Akshay Kishore.
Yeah, hand over this copy for my last bill.
Any paper is there?
I am handing over this, my lord. Keep it the record. এটা আমার কপি ওটা আগে একটা দিয়েছিলাম ওটা
ফাইল করেছেন কেউ আর আছে কোন পেপার
মানে might be
দেননি কেন
not before this court, before my lord justice.
Whatever may be, they must be placed on record. I am not finding anything.
আমার কাছেও পাচ্ছি না আমাদের এই সই করিয়ে কিছু কিন্তু দেয়নি এরকম
দিয়েছে বলছে
সই করিয়ে নিয়েছে সেটা দিসনি করছে
because it your lordship can keep it there because it is my landed friend is also received the same copy. So there is no doubt regarding the authenticity of this.
Okay,
बाकी respondent की तरह किया क्या?
please take down. This is this second appeal is filed in the year 1977.
Which one mine? Respect the history. এই সৃজনী একটা কপি দিয়ে দিচ্ছি আমাকে। ঠিক আছে হোয়াটসঅ্যাপে পাঠিয়ে দেন আপনি করা তখন
Consequent to the prevailing law at that time, substantial question of law was not framed. Now, at the time of hearing the appeal, according to direction, due to the change of amendment of the CPC, the second appeal has to be heard on the substantial question of law within bracket section 100 CPC. Now, on hearing the parties, this court framed the substantial question of law as follows to determine the second appeal. The substantial question of law are and what about the second appeal?
Others ready by the
Other,
time today?
everything ready? Paper, books,
Everything is ready.
everything ready.
Ready.
The matter is otherwise ready for hearing. Let the second appeal be fixed for hearing on 17th of January.
Third.
3rd of January.
3rd of January.
not third of January. It's
Because
Both of you has to be present, otherwise how can I proceed?
opening on 4th I suppose.
কে বললো তোকে? 3rd খুলছে।
But not on the date of people.
3rd or 2nd?
Second is
the opening day,
yeah.
and the first date for second appeal in
Is on
my
3rd.
court is 3rd.
That is why I want to take the
Come on, 17th, I say. Come on, 17th.
3rd. কেন 10th
Could it be on 10? Because my lord,
If both of you are agreed, then I cannot. Okay, 10.
কোথাও নামটা দিয়ে দাও
Next.
I am for the appellant. Your lordship can recall on the other day have said the application for substitution was not on record. And I pay your lordship's leave, my lord, to file the Xerox copy of the applications and your lordship's directed.
Where is the can? Monday. Give it to me.
Two appeals, my lord, two applications, my lord. There are two appeals, my lord. One is 648 and another is 649. My lord, appellant number 2, my lord, in 648.
Can 2 in both the appeals?
Can 2 in both the appeals.
Second appeal 648 and 649.
Yes.
1994.
Yes.
So, so what is the prayer of
The
substitution?
applications are within time.
Who died?
Appellant number 2, Ajanta Bhattacharya Doctor has expired, on November 23rd, 2020, and this application was filed on 11th February 2021. That is within 90 days. If your lordship kindly see, paragraph 2 at page 4 of the application, I have said that during the pendency of the appeal, Srimati Ajanta Bhattacharya, appellant number 2 expired on 23rd November 2020, leaving behind the following persons as her heirs and legal representatives. Well, instead of the Anima Bhattacharya, this name may be recorded in the memorandum of appeal. All these names to be substituted instead and place of Ajanta Bhattacharya.
Service of notice upon the respondents are waived.
Because at that point of time when the appeal was admitted, one learned advocate appeared and notice was waived.
And the name of respondent number 1 was struck off. Tapan Kumar Roy in the year 2006.
May I be permitted to go through the of your lordship's part
I
one,
must.
so that
I will hand you over, no issue. Just wait, বসুন চুপ করে। Okay, please take down. Can 2 of 2021. Can 2 of 2021 is not placed with this record. Learned counsel appearing for the appellant handed over a copy of the CAN application. Let the office copy of the let the said copy be taken on record. Full stop. The department is directed to place the CAN 2 of 2021 with this record in the urgent date. Next paragraph. This is an application for substitution of legal heirs of deceased respondent appellant number 2 Anima Ajanta Bhattacharya 3 Ajanta Bhattacharya. It appears that the instant application is filed within the statutory period of limitation. Accordingly, the instant application being true and bona fide is required to be allowed. Thus, the application for substitution being CAN 2 of 2021 is allowed and disposed of. Full stop. Department is directed to make out the necessary correction in the cause title of the memo of appeal in terms of paragraph 2 of the instant application by substituting the name of the legal heirs of the deceased appellant number 3 in the cause title of the memo within a fortnight. Full stop. Next paragraph. The appellant, full stop, none appears on behalf of the respondent. Full stop. This matter appears before this court after long intervals. Long intervals. Long intervals. Considering the situation, the appellant is directed to serve the notice upon the respondent, intimating them that the matter shall appear in the list, in the monthly list of February 2025.
May I pray before your lordship to be listed in the month list of January instead of February?
You have to serve upon them, serve a notice upon the respondent. There is a fixed on. The monthly list would be appear first.
Your lordship kindly give me leave to go through the records so that I can ascertain on.
Okay. Learned counsel for the appellant is at leave to inspect the record for causing necessary service upon the respondent. Both the দুটোতেই হবে দুটোতেই হবে item number 18 118 119 okay same
I'm getting.
Next.
One 120, your lordship, for the appellant, your lordship, Mr. Romindod Mahato is appearing online, your lordship.
Accusation. But I have the instruction to appear on behalf of the respondent, my lord.
Yes.
My lord, I believe, my lord, one application, my lord, has been filed for the Honorable Court, my lord, for deletion of the name, my lord, which has been served upon me.
What is the application being can?
But I believe it is can 11 of 2022. My lord, it has been, my lord, filed by them. My lord, may I just request one thing to your lordship? My lord, because this is for deletion of the name of one of the legal heirs of the respondents.
One of the legal heirs of the respondent.
So, my lord, I am representing the respondent here. So, my lord, I'll just take instruction to that effect from my client once. Because if any other legal heirs are surviving apart from the persons who are already there on the record. Because they are saying that the legal heirs of the respondent
are all on the record.
Are there on the record. I'll just take instruction whether that submission is right.
It should be verified. In that sense, it should be verified.
Only I just take the instruction and come back to you, Lord.
My lord, I have no objection to that.
Because if this is the thing. But could it be your lordship's pleasure, my lord, to put it on the next Friday, my lord? I'll be just taking instruction this minute.
Okay. Please take down.
But for that reason, my lord, it can be listed on next Friday. But for hearing, my lord, I have some difficulty in my operation. I have undergone one operation. My lord, I shall join the court, my lord, on the first week of January.
All right, let it be, my lord.
Let the application.
Yes.
So far, this application is concerned, it may be disposed of on next Friday.
Okay. Yes. Okay. And 11 of 2022. This is an application for deletion of name of one respondent, namely Parul Bala Das
Tanti.
ENTI. Full stop. Learned counsel appearing on behalf of all respondents submits that he needs some instruction for disposal of the application being can 11 of 2022. Concerning the submission, the matter be adjourned today. Let the matter be listed on 13th of December under the heading of application.
Grateful.
Next.
I am appearing of the appellant.
I am appearing for the plaintiff defendant, number 1 and 2.
Yes.
Proceed.
So you are appearing on behalf of the appellant. And you are for the respondent.
Plaintiff.
Service complete.
Everything is complete. Paperwork is complete. LCR also completed.
Only for 1 and 2. If you know about 3 and 4. Page number 34.
You are appearing on behalf of all the respondents.
Can you keep page number 34?
Page number 34.
34
Of what?
paper.
Paper. What is the memo?
And for the plaintiff, that is 1 and 2.
মেমোটা কোথায় রাখছি? আচ্ছা।
পুরানো কপি দেখতে পেপার তো নতুন কাগজ হবে পেপার তো নতুন কাগজ হবে
পেপার বুকটা
মেমোটা পেপার বুকটা দিন।
ওইটা আছে এখানে এসে পেজ নাম্বার 34
পেজ নাম্বার 34 Yes.
The top, I'm applying for the plaintiff, that is defendant number 1 and 2.
Respondent number 1 and 2.
Respondent number 1 and 2.
Yes.
But I'm not applying for 3 and 4.
3, 4 service completed. In the both the courts below, possibly they are not contested. Yes. Trial court judgment, page number 10, lawsuit. Only contesting defendant of 1 and 2. That is the pigeon appeal.
Respondent number 3 and 4.
For experting in the court below. And also initially in their appeal, one of the advocate appear. But now they are not interested to appear this matter. Even now 1 and 2 is the contesting. Now it's the present appeal. My client. Suit for partition.
Suit for partition.
Partition suit dismissed. Defendant plaintiff waiver and appeal. Appeal. Against that present.
So now the respondent number 3 and 4 is required for the hearing or not?
So if they are not choose not to appear, it can proceed it because
No,
trial
this
could also
is
consider it
appear,
for-
this matter is appearing long intervals.
long it was running in the list before earlier bench, and so many times was
No, you are saying that someone is appearing on behalf of respondent number 3 and 4?
yes, someone, so Mr. Somen Dotto. Initially I served a notice to one or
No,
twice.
before this court, whether you have served a notice?
Now they are refused to receive this notice.
No, whether you have served?
No, they refused to. How can I serve?
They refused after listing this matter before this court.
Before listing, I should not.
Then you have to serve a
Before the earlier bench,
No, you have to serve the notice upon them. Otherwise, it will be difficulty, or otherwise, some order has to be passed against 3 and 4.
Maybe. Plus,
Unless, how can I proceed? This is a partition suit. The respondent number 3 and 4 may be the co-sharer of the land or
respondent number 3 share devolved upon my client.
4.
4 is not no share at all.
So if you want, I can pass an order. It on your risk.
Because my as per the record says the lawsuit, the 3 defendant number 3 share devolved upon that defendant number 1 and 2.
And what about the defendant number 4? Respondent number 4. If you want their name can be expunged. If you want. It is purely your risk.
So say I can serve another notice. Then
You
come
serve.
back.
It will better. It will better.
If the learned lawyer not receive the notice, then
You are appearing on behalf of the respondent number 1 and 2.
this is a plaintiff.
Now respondent number 1 and 2. Okay. Please take down.
তুমি কি অ্যাপিয়ার মানে হাজির হয়েছিল কোনোদিন না?
Appellants as well as the respondent number 1 and 2 are represented through their learned advocates. None appears on behalf of the respondent number 3 and 4. Full stop. Next, for learned counsel for the appellant submits that before a coordinate bench when the matter was called on for hearing. Learned counsel who appeared?
Mr. Somen Dotto.
Mr. Somen Dotto appeared on behalf of the respondent number 3 and 4. But subsequently he did not turn up. Concerning the submission, the appellant is directed to serve a notice upon the learned counsel who appeared earlier on behalf of the respondent number 3 and 4 regarding the adjourned date. Let the matter appears in the list on 3rd of January under the same heading. The learned counsel for the appellant is directed to serve a notice as mentioned above and file an affidavit of service on the returnable date.
May I permitted to go through the record?
Why?
Just admission order. Because our copy of the admission order was not with me, so that I can only see the admission order.
You go to the department and passing the order. Department shall allow learned counsel for the appellant to inspect the record. Allow the learned counsel for the appellant to inspect the record.
I am for the applicant. But last occasion, there is a direction for service matter. I have served
122.
122 Lordship, Mr. Joantudash is appearing for respondent number 11A to F Lordship. Regarding this application, we need to take some instructions, Lordship. I'm praying for not this week.
What is the application
My
about?
application for substitution, they have served notice, my lord. Just kindly see, they have served notice.
What instruction you required?
Yes, my lord. Kindly see page 10 of this application. On his letter, my lord, I have immediately thereafter I made this application. You have to kindly allow this application and fix it. 2000 matter, my lord. They are trying to disturb my lord, status quo order in my land. So this is the very hard situation of my client. So you have to kindly go through the page 10 of this application.
We have served the notice, Lordship, upon them, Lordship, but
On the basis
my senior needs to take some instructions, Lordship. I'm praying for only not this week on his ground.
Application for substitution upon setting aside abatement.
Yes, my lord. Actually, they have informed my lord on 2024. 7/10/2004. So that the time has been elapsed. On that basis, my lord, this application, immediately after receiving this application, I have filed this.
Then you have to file 2 applications, not the single application.
But that was admitted previously by this honorable court in previous officer. So
It is the situation otherwise.
so for this reason, my lord,
Order may be passed by required 2 applications.
it has been accepted by this previous occasion, my lord. So in this regard, my lord, previous occasion, this honorable court has been
Very well. Come on. Next Friday.
Lordship.
Next Friday.
yes, sir.
An accommodation is sought for on behalf of the respondent. Let the matter be adjourned to release the matter on 13th.
Grateful to you.
Yes, sir. Kindly keep one order, my lord, as per previous direction.
Under
my
the heading of application. Yes.
previous occasion, I have served all notice, my lord, as per order of this court.
Okay. Affidavit of service
Previous
file on behalf of the
kept to the
applicant is taken on record.
Yes, ma'am. Yes, sir.
Maybe your lordship. That this is a transfer deed, but when I have got the Wakalatnama, it reveals that one of the appellant only signed. There are other appellants is there, my lord, after substitution. My lord, one Prafullo Vishwas was the appellant. Thereafter, after his death, my lord, four persons are substituted. A daughter, son, my lord, only one person has given the Wakalatnama. So, my lord, your lordship kindly adjourn the matter. I will take other instruction whether they are giving the kindly see the memorandum of appeal, my lord. না টাইম চাইছি আমি তো আধা সেটেল লয়ার কে আছে এই স্মল কজে বসে তো ঠিক আছে টাইম হয়ে যাচ্ছে কেন একজন আমাকে দিয়েছে বাবা 4 জনের পাওয়ার দরকার চলবে দাঁড়িয়ে যাও বা দেখে যাও
Please take down. It is reported that requisites upon the substituted respondent number 1A to 1D have not been put in.
have not been
Not put in.
Oh.
You have not filed the requisites. Considering the situation, the appellant is directed to take proper steps for service upon respondent number 1A to 1D. Full stop. Learned counsel for the appellant 6 accommodation for taking proper steps. According the matter be go out of the list. Appellant is liberty to mention the matter after compliance, after due compliance.
My lord, subject to correction, earlier occasion one matter your lordship direct me to file an FIR where the LCR had not trace out. As a reader, your lordship direct me to file FIR.
Which
So, my lord,
matter?
I have filed the FIR before the
Which matter?
Justice of India Supreme Court, my lord.
Which matter?
The matter is still pending for hearing before your lordship.
Today it is listed?
No, yes, today is listed. The matter is fixed on 13th.
Okay. You come on that date?
Yes, I have made.
I could not remember it. No?
I made an FIR
Okay,
before the
next
Chief Justice containing entire other. His Lordship Justice Samanto direct me to file FIR regarding the trace out of the.
There is no order that I have.
Verbal order your Lordship passed in open court. That is why I have communicated.
Okay, very good. Very good. Yes. Next.
124.
My lord, I appear on behalf of the respondent plaintiff, my lord. But there is a direction on the last occasion, my lord, to submit, and I have already submitted the notes of arguments, my lord.
My lord, I have been informed with the 2 months of penalty is appearing for the appellant matter. Another court.
My lord, let it pass.
Pass. I pray for pass.
Today is fixed for hearing of the appeal.
Lordship. Written submission decision I have already submitted by me.
Whether I have heard it?
No.
Okay.
Justice Sampadak took order.
Then why are you placing this before me?
Again, I will place, my lord, this is the
Go to the Justice Paul.
No. My lord, this is the position of the case, my lord.
If you wish, I can release it.
Every time for last 20 years, my lord, they have taken adjournment. That is why I have
Not in this matter for
last 20 years, my lord. Every day adjournment is
No. Situation is otherwise. If we start again, you have to start again.
Lordship.
Otherwise, if you want to place this matter before the Justice Dr. Paul, I can release it. What is your option?
I will place the matter.
You will place the matter de novo before this court. Okay. Yes.
What can you hear about the matter?
Okay, pass it over now.
Great.
I am appealing for the appellant. Appellant is the defendant.
I am for the respondent number 1 ABC, and I will file Lokalodna in respect of T, A, B, and C. Lord, the paper book, my lord, which has been prepared and supplied to me, it contains only this decree and judgment of the appeal court and the trial court, but all other details like plaint, depositions and other things will be required. For this reason, my lord, paper book, my lord, I think, my lord, they should file a supplementary paper book incorporating all. I tell you, lordship, my lord, this is a shoot of 1992. No paper is with me. 1992, my lord, that erstwhile advocate, my lord, of the trial court has already died.
Just a few minutes
My
back,
client.
Just a few minutes back, my lord, I was hearing from my another learned advocate friend that in the second appeal paper book plain statement are not included. I told him that it's not required. This is the
now what is the rule?
Judgment and decree of both the court and the order allowing admitting
the decree of title suit, decree of suit,
yes,
and thereafter the first appellate court, decree of first appellate court, and thereafter the order admitting the appeal. second appeal. These are the requirement according to the rule. These are only requirement for the second appeal paper book. First appeal paper book is otherwise. That is voluminous.
Part 1, Part 2.
Part 1, Part 2 is there. In second appeal, there are specific rule is there.
But Milord, I do
Only
not have
decrease
other
and the
paper.
order admitting appeal.
Other papers, Milord, I do not have
Get
anything.
it from your
19,
client. Get
my
it from
client
your
also do not have because the erstwhile advocate died and he didn't return any document. 1992 shoot. But other documents will be necessary.
LCR is there, get it.
But then I'll have to get certified copy of
Yes,
this.
you have to have a certified copy. This is the rule. You can have the certified copy. LCR is here, I think.
Yes.
LCR has reached.
LCR is it, my lord?
LCR examined and found complete. LCR
I will get certified copy, Milord.
No, you are appearing on behalf of all the respondents.
No, I am appearing for 1 A, B, C, and I will file local number in respect of 3 A, B, and C.
C, A, B, and C.
Yes.
What about the other respondents?
Since it is ready for hearing, my lord, probably, my lord, I have to go through it. My lord, the orders that whether the notice of appeal has been served on all the orders or not. Because it is substitution. It must be, my lord, by court's order. Substitution of the respondents, plaintiff respondent as well as of the defendant respondent. Some.
Yes, it is ready for hearing.
Ready for hearing.
Everything is ready.
In 1 A, B,
Service complete.
1
A, B, C,
B, C,
3 A, B, and C.
A, B, C.
Yes.
After
Kajol. 93317 683.6. 10 নম্বর। Other respondents will
ready for hearing. Because actually, I tell your lordship.
Can you start today? Can you start today?
Lord, your lordship, kindly grant me 2 weeks time so that, Milord, I can get all other copies. Except other copies, Milord, it will be absolutely very difficult, Milord, the second appeal matter.
Lord, if I may be allowed to, I can, Lord, start and give an outline of the.
No, otherwise my land friend should supply me all the other documents. Then, Milord, your lordship, on the next Friday, the matter may be hard.
Better.
আপনার কাছে আছে বাকি ডকুমেন্টস গুলো? Milord, let them supply me.
যেগুলো আছে আমার কাছে আপনি আসবেন আমি জেরক্স করে দিই নিশ্চয়ই ফর দ্য এন্ডস অফ জাস্টিস তাড়াতাড়ি হয়ে Anashidi may be claimed, gifted the property, claimed protection, honors shifted to defendant. Judgment.
What is the order admitting the second appeal?
Oh, আছে এখানে?
Show me the page.
I'm sure. Budget. No. It is not there.
Just I want to find out what are the substantial questions of law.
No, it is not there.
It is not placed. You place it.
No, it is not there. Man. It is not in the paper.
Not there. Okay, then you have to file one supplementary paper book. Please take down. appellant is leave to file a supplementary paper book containing the order admitting appeal along with the substantial question of law on the basis of which the second appeal would be heard. Let the matter go out of the list after preparation of the.
My lord, your lordship kindly may kindly, in January anything, by that time I only want.
Then you mention it, serve it and mention it.
My lordship kindly fix a date anything in January.
Within that time, can you
Yes,
prepare
yes.
it?
Only order will be
No,
only that. In January anyway.
let the matter appear in the list on January 24. Full stop. Learned appellant is learned counsel for the appellant is directed to submit the requisite number of supplementary paper book with the department after serving a copy of the same to the learned advocate for the respondent.
But in the meantime, I'll obtain certified copy of.
You can take it, no issue. You serve a copy of supplementary paper book.
Supplementary book I must.
Next,
Date may kindly January.
I have fixed 24th of January.
I could not.
26.
In this
My
matter, I am
respondent, my
for the appellant, my lord. Defendant appellant before your lordship, my lord. I am praying not today only, my lord. Mr. Ganesh Srivastava appearing, my lord. Due to some medical emergency, he has not come today, my lord.
You are for the appellant.
Appellant.
You are for the respondent.
My
Is he
lord.
ready
All
for
the
the
respondents.
My lord. I am led by Mr. Devashish Rai and Saurabh and senior advocates.
Okay, everything is ready in this matter.
ready? Is he ready for hearing?
Paper books are
Yes,
ready.
Lordship.
Long. Eh?
Oh. Next week. Next week.
I am appearing for the appellant, my lord, respondent in an application filed on behalf of the respondent plaintiff. But my preliminary objection to the application is that the application is not maintainable. Now, my lord,
I understand, my learned friend. I'll just indicate because.
What is the application?
Lordship, I'll just indicate because I require 5 minutes. This was the appeal file. Application is for the modification of the order admitting the second appeal of 6th April 2005. Now, I have two requests. First of all, Your Lordship, when the appeal was admitted, paper books were to be filed. We had mentioned several occasions paper books were not completed. If Your Lordship recalls, if they do not comply or everything, we have also prepared the entire compilation. Because what will happen after this application is heard, Your Lordship will finally read it for hearing of the appeal also. So, because I do not want, because question is, I am the landlord decree holder who is suffering this order and the appellants are not taking steps or pursuing this appeal. I want to expedite. Now, my reason of making an application is the modification of the order by which the appeal was admitted. Lordship, there is a change in law on the basis of which the application has been filed. When the appeal was filed and admitted the second appeal, the directions were upon the appellant to continue to pay the last paid rental charges. The last paid rental charges is
if my learned friend wants to argue the application, I'm ready. Otherwise, I'll be seeking a direction to file affidavit.
Very well. There is a query. I need to place my application before you press my opposition because I am pressing for an ad interim order today. You may place an opposition. I don't mind. My application is that as of yet, because of the change.
There is no prayer for ad interim.
Lordship, let me place my application, sir.
There is no prayer for ad interim.
Sir, let me place my application.
So, what is the application?
Yes, Can 9.
It's an application for modification of an order passed in
Can
2005.
Kindly comes to my application.
After 20 years.
Yes, yes. The trouble of the decree holder starts with all this. So that is the reason we have to do
Yes, yes,
something.
yes. And you don't have locus standi, that's a finding of the court.
Yes.
And you want to jump that legal proposition.
Yes, sir.
So who is facing trouble? It's known.
Yes.
It's on printed black and white.
Yes.
So it's better you don't open your mouth too wide.
I don't want your
Yes,
advice.
yes,
sir.
yes, please.
Let
I
me
know.
urge the application. That's
Yeah.
it.
Don't comment on the appellant.
I'll give a 2 minutes summary of my application.
No, let me find out the application first.
Yes, it's a CAN 9 which has been filed this week. CAN 9. Yes. Application extra material. If I can have over my application for ease of reference, I'll take it.
Patient. List এসছে তো। তোকে না পাঠিয়ে রেকর্ডটা পাঠাই কেন? কেন না দিয়ে? স্যার না নেবেন না, রেকর্ড নেবেন না। Yes.
But it kindly comes to page 63, which is the order which is sought for modification. Lordship has page 63.
Yes.
So I am placing this is the appeal is admitted for hearing on ground number 3. The appellant petition is given leave to correct the cost title of the petition and the phrase portion of the state petition. The service of such and such is complete. I am just coming to the third file. The suit is for eviction under the provision of the West Bengal Premises and Act 56, which has been decreed by both the courts below. Since the appeal has been admitted for hearing under Order 41 Rule 11, we are of the view that the execution of the said decree pending disposal of the appeal will invite multiplicity of suits. Accordingly, we grant stay of all further proceedings of execution for a period of 6 months from date or till the disposal of the appeal, whichever is earlier, with a liberty to apply for extension in the event appeal is not disposed of within the aforesaid time period. The interim order is being continuing for some time. The grounds have been defendant appellant will deposit the areas of rent if there are any, and all decretative dues within a period of 4 weeks of the executing court. The defendant appellant will go on to pay occupation charges at the rate of monthly rental, at which it was lastly paid for the month of April 2005, which shall be deposited by 15th of May and thereafter for every month by 15th of succeeding month. I pause here for a minute. Because of the change in law, I am seeking modification of this direction which was passed. I'll place it. In default of the deposited amount and current occupation charges for consecutive 2 months, the interim order shall stand vacated. The hearing of the appeal is expedited in view of appearance on behalf of the sole respondent. The appeal notice is being given, and directions defendant appellant will prepare requisite paper books without certificate period. To our understanding and knowledge, paper books have not been prepared. I do not know. I'll correct if my learned friend indicates that. While we have prepared the compilation. So today, what I am for? I am for seeking modification of this order, whereby the appellant has been permitted to occupy the premises at the last monthly rental rent. My first twofold submission is,
what modification you want?
I want they should pay at the current market value.
Current market value?
Yes.
Okay.
Because the property which is in question is in a premium location. We have disclosed in our application the monthly let out value of whatever is the area. We have disclosed the agreement. And considering that, the assessment of that rent is incorrect. Why I say so? Kindly, Your Lordship takes over this decision. Because I have prayers.
No, just I want to know.
Hearing out
I have prayers for claiming arrears. But today, what I want from today onwards, they should pay the occupation charges at the rate of 1 lakh rupees per month. That's my interim prayer. Kindly comes to my prayer, Your Lordship. I am seeking for prayer C at page 8.
Where is the interim prayer? Where is the prayer for interim order? Interim or ad interim, whatever it is.
May I submit, sir? I will not interject you. Let me complete my submission. Then I will respectfully give us a time.
Okay. You want this modification?
I want this modification. I want this modification as more fully stated. Kindly comes to paragraph 11 of my application. 11, 12, 13. That is the modification because that was not there. The law was what was at the time of passing the order has now evolved. Today, a property which is worth of a reasonably value cannot be put to me on occupation charges of the rent, which is around only 450 rupees. The total area is 1,482 square feet.
Whatever maybe. So, what is your submission? You want to use affidavit?
I want to use affidavit, but I have a preliminary objection pertaining to maintainability of this application. A modification is being sought after 20 years of passing of the initial order. Whether Limitation Act comes in the way is a question to be answered by my learned friend. That's number one. Number two, he is seeking a modification of an order passed by a division bench of this honorable court. Whether judicial propriety or law permits a modification of an order passed by a division bench by a honorable single bench. That's question number two to be decided. The third, my learned friend is relying upon Atmaram, which was decided.
I never decided Atmaram. I never said Atmaram.
Anyhow, in Atmaram, it was decided in 2004 December that current occupational charges were to be paid in December 2004. This orders for which modification is being sought for was passed in April 2005 when the Supreme Court order was already there. Taking into consideration that order, the Honorable Division Bench of this court had passed an order which is there at page 63. My lord, I don't know, this is basics and elementary that a division bench order cannot be sought for modification before an honorable single bench.
It's incorrect.
Please, please. You said you will not interject. You said you will not interject.
Yes.
And a modification application filed after 20 years. I don't think the Limitation Act has gone down the river Ganges.
Very well. You use it.
My lord, this is being filed after 20 years. So I'll be
next week. Next week.
I want to file a. I want to file a affidavit in opposition. I'll be requiring at least 8 weeks time. They took 20 years to file a modification application.
No, they have not filed a paper book for 20 years.
My lord, I have filed paper books. I have documents to show. Let him not make bold allegations, my lord, without knowing the facts of the
I
case.
want to hear it out. So I want to hear it out. Use affidavit within first week of January. Thereafter, I
Doctor will give me some sufficient time. Papers are to be brought. Only knows this is a 2004 matter.
I am giving you 4 weeks time.
Little more, 6 weeks. I'll not bargain with your lordship.
Okay. Very well. Please take down.
हमारी instruction भाई junior
Can 9 of 2024. This is an application for modification of order.
I don't know when it was filed, but
modification. This is an application seeking modification, variation,
please ask for it.
Or recalling of order dated 6th April 2005, passed by this court in Can 9/30 of 2015 in connection with this appeal, this second appeal. Full stop. Learned counsel appearing on behalf of the respondent wants to use affidavit. against the application. Learned counsel for the petitioner, respondent submits that the application is required to be heard promptly. Considering the situation, the matter we adjourned today, the petitioner, appellant is at leave to file affidavit in opposition against Can 9 of 2024 within second week of January. Let the matter appear in the list on 17th of January under the heading of application. 17th of January is the date.
Grateful.
Grateful, man.
Shiva, I am for the respondent.
For the appellant, my lord, the special messenger cost has been paid, my lord, the LCR has been called for. The paper books are all but ready. Let the matter be fixed in on any day in January. The matter can be taken up.
Lord
for
Shiva, in the meantime, let them serve me a copy of the paper.
I have to serve, my lord, to file the paper book before the department. I'll have
It
to
is
serve.
pending from 2006, Lordship. Did be heard out.
Deletion. अरे ना ना मैं पूरी दिला
It has been reported that you have to serve
I have.
notice of appeal upon substituted respondent number 2A.
Those have been done. But after that, there was direction to file the special messenger cost.
That is for LCR.
That has been done, my lord.
No.
They are appearing for the respondents.
No, are you appearing for all the respondents?
No, we are not appearing for all.
It is reported that in respect of respondent number 2A,
এর হয়ে আপনি ওকালতনামা পাবেন? এ হলো এই যে প্রভা করপাল। দিয়েছে রিপোর্ট দিয়েছে।
রিপোর্ট দিয়েছে
আপনি কি ওদের ওকালতনামা পাবেন?
জিজ্ঞেস করতে হবে আমি এখন বাইরে এক্ষুনি জিজ্ঞেস করতে পারছি শুধু তো অমৃতারঞ্জন পাল
দেখুন
ওকালতনামা দিয়েছে
আমরা সব রেসপন্ডেন্ট দেখছি।
only 2A is left. You have to serve.
It was written as for respondents. I was under the impression that they were appearing for all the respondents.
No, they are appearing, but the department has checked the record and said that 2A is left.
Yes, Lordship, I was appearing for only respondent number 1. Because respondent number 2 died. That is why I could not take
Died. That's why the substitution was there.
Appellant total on respondent বাকি যে মারা গেছে
Substitution. That can be taken care of by lord during within this week, my lord. Or this week, my next week.
Please take down. It is reported that the notice of appeal upon substituted respondent number 2A was not put in. No, requisite karo. তুমি কি বলো? না, requisite for it is reported court লিখে দিন. It is reported that requisite for effecting service of notice of appeal upon the substituted respondent number 2A was not put in by the appellant. Appellant is directed to take necessary steps regarding service of notice of appeal upon the substituted respondent number 2A. It is submitted by the learned counsel for the appellant that the paper book would be ready in very short intervals. Considering the situation, the appellant is directed to file the requisite number of paper book with the department after serving a copy of the same to the learned advocate for the respondent.
Or should be respondent number 1.
কি বললাম? A requisite number of paper books to the department after serving a copy of the same to the learned advocate for the respondent. Let the matter appear in the list under the same heading on 17th of January.
Lordship. Grateful
Since
Lordship.
I'm put in the special messenger course, let the direction upon be department to expedite the LCR to be called.
এখানে respondent
LCR,
number 1
you have already put in?
I have already put in, my lord.
Okay, okay. Department is directed to
ওটা করে দেবে।
to bring the trial court record through the special messenger, cost of which has already been deposited by the appellant.
I'm grateful, my lord. I'm extremely.
দাদা আমরা respondent number 1
1 হয়ে আছে আমরা দিয়েছি নামটা প্রবীর ব্যানার্জি আর সৈনী চট্টোপাধ্যায়
Next,
respondent number 1
But I was appearing for the
respondent plaintiff দেখুন লোয়ার কোর্টের এখানে রেসপন্ড
So I'm appearing for the appellant.
Lord, one fact has to be brought before your lordship. The respondent number 2 named in this appeal has expired. Now, respondent number 2 was an executor of the estate of a gentleman who was the tenant of the property in respect of which the suit was filed. Now, the suit was filed against one of the co-sharers and one executor. In the meantime, testamentary suit was filed, and as far as knowledge we could gather, the testamentary suit has been probated and the estate has been administered.
okay.
As also, the respondent number 2 has expired also. So respondent number 2 is to be substituted by the beneficiaries to the estate, and then only this proceeding can go ahead any further. So let the appellant, who was the plaintiff, take necessary steps for substituting or, my lord, bringing on record necessary parties instead of the deceased respondent number 2. That is my submission, though, my lord, I have really no specific locus standi to appear in this matter because my client is not yet a party, but I was appearing on behalf of the respondent number 2 who is no more. So this is the information as an officer of the court I am, my lord, conveying to the honorable court.
Lordship, only one thing.
One vocalatnama was filed on behalf of respondent number 2.
Vocalatnama?
Oh, they have reported like that. This is the
Lord,
report.
when it was filed, my lord, at
Let
that
me see, let me see.
lordship will kindly
Old
state-
vocalatnama is there.
Old vocalatnama, my lord, at that point of time, the respondent number 2 was surviving.
Okay, okay.
And may not be the estate was not administered. My lord, even if probate is granted and estate remains to be administered, then also the executor is to be a party by proposition of law. But my knowledge says that the estate has now been administered. And there's one more fact which I wish to draw your lordship's attention is 24th September order passed by the other bench of this honorable court was taking up the matter. There were certain directions given. I do not know whether they have been complied with also.
May I indicate?
Yes.
I am appearing for the appellant. This matter mentioned at our instance on previous occasion where we have attempted to serve the R1. I think my learned friend is appearing for respondent number 1.
No. We have never appeared for respondent number 1. Even the paper book,
It appeared at the time of admitting the appeal, parties were appearing. The difficulty is that I just want to know my learned friend is appearing for whom?
I was appearing for the respondent number 2, who has since expired. He was the executor of a will. The will has been since probated and the estate has been administered.
Administrator, the beneficiary attempted to add herself in the trial court. The application was rejected. Yes. Now the difficulty is the respondent number 1 is no more. That's what we are given to understand. We don't know the particulars. The respondent's lawyers, we attempted to contact, they are not there. The respondent number 2, Someone is occupying the premises, we attempt to serve, no information. My only myriad is that I have filed the appeal, I have put all the paper books, I have filed an application for occupation charges. It's the point where I was a decree holder in the first court. In the second court, the decree was reversed on relying on a principle of a judgment, which judgment has been subsequently overruled. Now, today, my learned friend, he is not appearing for respondent 1. He is also not appearing for respondent number 2.
Not appear for 2.
On the previous occasion, somebody appeared for respondent number 2. Some lawyer appeared for respondent number 2. Now, today, when I contact the lawyers, there are none. There is no beneficiary. The representative of the beneficiary application rejected. So there are no respondents per se. There is somebody who is occupying the premises who is only claiming.
Memo. Give me the memo. Memo of the second appeal.
Page 42 of the paper book, if your lordship has it.
Memo.
One Mr. Pushan Majumdar appeared for respondent number 2 and undertaken that he will file Wakalatnama. That's recorded in the order of 11 September.
And perhaps that was out of a wrong submission being made, because Mr. Majumdar is appearing today also. But he couldn't have submitted that he was appearing for the respondent number 2 when the respondent number 2 was no more. But it was gathered later on.
Only thing is that as an officer of the court, if Mr. Pushan Majumdar is
Lordship will kindly say 11-9 order. It says something different what my learned friend is saying. Mr. Pushan Majumdar, learned advocate, has not filed Wakalatnama to represent the respondent number 2, who according to him has expired, which is not within the knowledge of the learned advocate.
Intends
So
to
what
represent
submission
the second paragraph. He intends to represent.
He intends to represent the beneficiaries who will come through the respondent number 2. That is the simple law governing the subject.
Then,
law of succession.
Then as an officer, he has to indicate. He will not indicate.
The probate department is there.
I will not make inquiries here. He has to indicate he has passed.
No, the issue is that
the dominus litis is plenty.
Okay, no issue. Issue is that the respondent number 2 is no more now.
Yes.
This is the issue. You have to take steps. Whether you can substitute
right.
them.
He could have made the executor a party. Who informed him the executor to made a party? He gathered information that there was a will. Executor is there.
He has to
Today he
take
cannot gather information.
You may file the substitution, or you may file the expunge the name of everything.
I can
absolutely.
Today, I just want to know, Mr. Pushan Majumdar is appearing on whose behalf?
He is not appearing for anyone.
Not appearing. No. He is just appearing to inform the court about the development.
Whatever, maybe you have to take steps.
Yes.
I have to take steps, also pass directions, because the difficulty is over here. In this matter also, I have filed an application for modification of the order. My peculiar difficulty. In the property, there are occupiers who are claiming to be the beneficiary.
But you cannot find anyone to grab the
difficulty is that in a dismissed suit, he wants occupational charges. His suit has been
I think he
dismissed.
does not have a locus to comment on that application. He is not appearing.
Whatever, maybe no, that is not the issue here. So you have to take a step.
Lordship, then I will kindly direct for expungement of the name. That
you have to file an application.
I will file an application by the next date.
Absolutely.
Okay, you file an application. Okay. Please take down.
Law permits him.
What is the application can do?
Can 2 is for modification of the order.
Okay.
It commences to your lordship. Lordship will kindly record the information I have conveyed.
Okay.
That respondent number 2 as executor has expired.
Learned counsel Pushan Majumdar.
Yes.
Learned counsel Mr. Pushan Majumdar inform the court that the respondent number 2 has expired.
My lord, I am leading Mr. Majumdar.
Okay. No, Mr. Pusha Majumdar, leaded by learned senior counsel from now to now. ঠিক আছে? Informed that the respondent number 2 has already been expired. Full stop. Learned counsel for the appellant is directed to take proper steps in respect of deceased respondent number 2.
Lordship, it will be incorrect. Respondent number 2 was an executor. I will not array the representative of executor. Executor is appointed by the court. So it has to be the estate beneficiary.
No, you take steps upon respondent number 2.
Executors are appointed.
Whatever may be your steps, you take
Not
steps.
by the court.
You have to take steps. Otherwise, a appeal cannot be proceeded against a dead person.
The executor is the named person in the will, not someone appointed by the
Whatever may
court.
be, that is the otherwise.
Normally it is an administrator who is appointed by the court in an administrative.
Okay, let the matter be adjourned today. List the matter on 17th. 17th, same day?
Yes, Lordship.
17th.
Along with all my applications.
Applications already on the record.
I will also cause service of the application too, once I take steps. That's it.
You take steps, thereafter you have to serve.
Grateful, man.
Next. Which appearing in this matter? You mentioned Calcutta. Appellant respondent লিখবেন তো ঠিক আছে ঠিক আছে কেউ তো আসছে না সুইচ করেছেন পুরনো appeal none appears on behalf of parties. Let the matter go out of the list. Parties are limited mercy.
My lord,
Yes.
my lord, I am seeking an adjournment, my lord. My lord, I am led by Mr. Saptarshi Kumar Mal, my lord. He's kind of.
Who are you representing?
My lord, I am for the petitioner, my lord.
For the petitioner.
Appellant petitioner, my lord.
Appellant petition. What is the petition about?
My lord, there are three applications, my lord.
Yes.
My lord, first is for substitution, my lord. Second is for leave to allow the appellant petitioner to deposit an occupational charge to the respondent, my lord. And the third application, my lord, in the last order, if my lord takes up the last order, we had moved the application for substitution. Now, my lord, during the hearing, my lord, the honorable court, it fell from the honorable court that we had not preferred and application under seeking condonation of delay under the Limitation Act. Therefore, the honorable court had directed us to file an application for limitation. However, my lord, we in our application for substitution, we had already prayed for condonation of delay. Therefore, my lord, the last application is for the recall of the order directing us to file the Section 5 application.
Okay, who is appearing for the respondents?
My lord, we have served. There are affidavit services on record. However, on repeated occasions, none from the other side are.
Today, what
appearing.
is your submission?
My lord, today I am simply seeking an adjournment, my lord. I shall come on the other day and move the application.
Next week.
Next week, my lord.
Only next week.
Grateful.
Next.
Well, at 132 and 133, Mr. Ongshuman Chakraborty is appearing in this matter, my lord. His
On behalf
father-
of?
Respondent, my lord.
Okay.
On 28th November, his father has expired, my lord. My lord, kindly adjourn the matter for 2 weeks.
You are for the appellant.
Yes, your lordship. Your lordship, this is the transfer brief due to which there is some defect in the wakalatnama and the service of summons. Your Lordship, therefore, I kindly pray before you to kindly send it to the Law Zima department.
On the prayer of the learned counsel for the appellant, let the matter be go out of the list. Go out of the list. Appellant is directed to take appropriate steps according to law and mention the matter after due compliance. Next.
Gratefully, Your Lordship. My Lord.
Call the list.
My lord, I am for the petitioner, my lord.
What petitioner? Petitioner? What petition? No petition is pending. This is the appeal, second appeal.
Appellant, my lord.
Appellant.
Appellant, my lord.
Yes.
My lord, I am for the appellant. My senior engaged another saying not to it. And
You are?
But the respondent, is your, you're opposing the application, you're opposing the application. Are you? Is it? When? What, you take a passover and take instruction. One take one,
You are appearing in this matter.
yes. I am for that.
And what are you submitting? You take instruction, proper instruction. Are you appearing on behalf of the respondents?
Might be.
Yes, perhaps he is not aware about the matter. Who leading you in this matter?
Mr. Learned advocate.
Yes.
Tanmay Mukherjee is for the respondent. Okay, okay. So what is your instruction?
Saying not to it.
Okay, not to. This matter is ready matter.
Ready matter.
Come on, next week. We shall start next week the appeal hearing. The appeal is ready for hearing. Okay.
Better, 1 week there after, 5 nearly out of Bengal, first out.
Then it will be convenient to first week of January. Okay.
That will be better.
On the prayer of the parties, let the matter be adjourned today. List the matter on 10th of January. Next.
In my lord, item number 135, my lord, I'm appearing for the respondents, my lord. My lord, the only difficulty is that, my lord, the learned advocate on record, Mr. Bolailal Shah, my lord, is not available, my lord, due to his personal inconvenience. I'm praying for a week accommodation, my lord.
No, what are the can pending since 2010?
That to be very candid, my lord, I'm not acquainted with the facts, my lord. I just
You know who filed the can?
Really, appellant is not contacting with me. I have no instruction. That is the whole difficulty.
So who mentioned this matter? You mentioned this matter?
No, probably, my lord, the mentioning has been done on behalf of the
appellant for the respondent mentioned this matter. Respondent mentioned
Yes,
this
yes, on behalf of Mr.
What is your instruction now?
I have received, my lord, to pray for a week accommodation, my lord, due to his personal
It
difficulty.
means not this year.
Coming week, my lord, let it be on Friday, my lord. Let it be on coming Friday. Subject to Lordship's gracious convenience, my lord.
No, I have already busy on the 13th. I have fixed several matters. And then next week, I would not be there. Okay.
A matter of 2007, my lord, kindly consider that.
Let the matter appear in the list on 3rd of January under the same heading. Next. One 136 and 137. No one is appealing? ছেড়ে দিন।
At 138, my lord, I beg to appear on behalf of the appellant. But I would inform your lordship that the respondents in this matter, my lord, has already expired. We have filed a substitution application that was allowed. Records were directed to be corrected by the department. That has also been done, my lord. The appeal is ready for hearing. Now the problem is what fell from your lordship is that the paper book must contain the order which admits the appeal, framing the substantial question of law. That is not in the paper.
Why not?
That is not in the paper book, my lord. That is my fault. This is the only thing that is missing. Otherwise, the judgment and decree of both the courts are present, and the memo of appeal is also present.
Very well. Let me see the paper.
Very, very good.
Give me 138.
But this is a judgment of reversal. The plaintiff appellant is before your lordship. I am representing their interest. Suit was decreed by the learned trial court.
Have you served upon the legal heirs of the deceased respondent?
Yes, my lord. The affidavit of service is on record. The order admitting
Me? That is surprising.
My lord, I am led by Mr. Ron.
That's a mistake, my lord. That should have been there. Okay, you filed supplementary. Supplementary paper book. Very by the next day. No one is appearing on behalf of the respondents.
Lord, they chose not to appear, my lord. There has, if your lordship sees, my lord, the records.
Record, they have reported that you have not taken steps. I think this is the report. No steps has been taken by the appellant for service of notice upon the legal heirs of the deceased sole respondent. This is the report.
না তারপরে তো পাঠাতে হবে না তাকে ডাকতে হবে lord we'll have to take steps.
Okay. Please take down. It is reported by the department that no steps has been taken by the appellant for service of notice of appeal upon the legal heirs of the deceased sole respondent. Also, appellant is directed to take appropriate steps. Appellant is also at leave to file supplementary paper book. Requisite number of supplementary paper book. Requisite number of supplementary paper book. And file the same with the department. Let the matter go out of the list.
No, my lord, kindly keeps it next Friday.
Then next Friday it will be possible for
Yes, we did all in Calcutta.
Okay. And let the matter appear in the list on 13th.
So
13th of December. Under the same heading.
So grateful. 13th, I'm sure, my lord, the matter will not be heard, but at least they can come and appear before your lord.
Yes.
My lord, passport matter 124, my lord. He is not coming, my lord, appellant.
Let me call other matters. I have some few matters. You are seeing that the only 1 to 2 minutes are required. Okay, next. 139 is there?
39.
Yes.
Here for the respondent.
I beg to appear on behalf of the appellant.
I am for the respondent.
Second.
Give me the paper.
Malot, I start Malot. Already Malot it has
You are appearing on behalf of
appellant.
appellants.
And Malot written notes of argument filed by both the parties.
Very well.
Malot, can you fix a date, specific date, Malot, because Malot today I think it will not conclude within Malot.
আস্তে আস্তে shortcut করা দরকার নেই।
20 করে দাও। 20
You are appealing for the respondent.
I am for the respondent.
আচ্ছা, না 13 তারিখে থাকছে। 24 না 13 20.
If you can start today for 5 minutes or 10 minutes, whatever may be, then it can be made part hard.
Yes.
That is, for your reason, it can be concluded. Otherwise, it cannot be started.
That would be better.
That's why if you want to demonstrate the entire facts, and where is the paper books?
Paper 5. Similar problem is that Malot, like earlier matter, with it's a change break, the substantial question law has not been included.
This is the appeal of 2010.
Yes.
There must have been a substantial
Yes,
question of law,
It is not included.
but you have not added
That is
in the paper book.
That order is not. Order passed by the Honorable Justice Malot Division Bench, decided by Honorable Justice Subramanian Mukherjee.
You have only placed the memo of appeal.
'79, 2010, Malot. And this is the order.
Yes.
Yes, Malot. So I shall, Malot, travel within the scope of this Malot substantial question of law. The fact of the case is that the 20 the kindly Malot takes the complaint at first. I have filed a suit for declaration of my title in respect of Procedural. I am in position. Admittedly, I am in position.
You are the plaintiff.
Plaintiff in the suit.
Plaintiff appellant.
Appellant.
Suit for declaration and injunction.
Declaration and injunctions.
Yes. What declaration you sought for?
Declaration is that, Malot, co-scheduled property in respect of the co-scheduled property is, Malot, property of the plaintiff or the appellant. And, Malot, Kho 1, Kho 2, Kho 3 and Go. All
Yes.
these are deeds are null and void.
Okay.
Inoperative.
So you have challenged how many deeds?
4 deeds.
4 deeds.
4 deeds.
These are the registered deed of sale.
Sell.
Registered deed of sale you have challenged. No, I want to know the nature of the deeds.
Sell deed.
Sale deeds.
Sale deed.
Sale deeds, registered sale deed, you have challenged.
Challenge.
Okay. 4 registered sale deeds.
That's why, my lord, the question, my lord, very substantial question of law formulated that I will come later on. Whether a rustic village, whether the every portion counts of the Registration Act will be followed or not in case of a rustic village lady. So, here the plaintiff, my lord, was, my lord, only a, my lord, illiterate, my lord, lady. She can only sign. That evidence is there. So, all the defendants previously they were, my lord, the tenant in respect of the property. So,
No, okay. Okay. So now substantial question of law is that you have challenged by plaintiff, you have challenged 4 registered sale deeds. So whatever may be the decree and 2 deeds, decree to 2 decree is there, but the substantial question of law framed whether the deeds
yes. Whether the learned judge
executed by the plaintiff were valid.
Yes.
In as much as plaintiff was a rustic village widow.
Yes.
This is the only substantial question of law.
And second, my lord, 2 points is there, my lord.
And
It is, my lord,
a wrong legal
interlinked.
test concerning the case of the rustic village widow and blindly relying upon the okay.
And interlinked, my lord, to another question is that whether the learned court below was correct in, my lord, granting decree in favor of the defendant.
Okay.
That is also there. Because, my lord,
So in title suit was decreed or dismissed?
My suit decree, my lord,
Decreed, no, dismissed.
No, first time it was decreed. First
Okay,
time
first decree.
Yes, yes.
Thereafter reversal.
Yes.
Then you have prepared the second appeal. Appeal after reversal. Second appeal. Now, this appears to be simply point of law and the observation of the learned trial courts.
Because it will go, I shall, my lord, advance my argument, my lord, considering, my lord, section 19 of the Indian Contract Act, when as to the nature and character of the document, as to the, my lord, contents of the document is voidable. But when it is misrepresentation of fact as to the character of the document, that is void. So here in this case, all the defendants were residing with the plaintiff. They had a very good relationship. Even, my lord, that is evidence is also there. They called the plaintiff as Guru Mata. So, under this impression, Dharma Mata, yes, Dharma Mata. So, under this relationship, one day.
Can you say this is a fiduciary relationship?
Fiduciary, no, that is no such, because they are business, only business transaction, because they used to sell the puff rice.
Okay. Not then such relationship is not there.
So one day they went into the registration office saying that because due to her old age, she could not look after the property. They took her to the registration office saying that power of attorney will be registered in favor of those persons. Under that belief, she put the signature. That
and executed the 4 sale deeds.
3 sale deeds. Thereafter, another sale deed, they, my lord, minor, enter property transferred by the 3 sale deeds in favor of the defendant. By another, that is the last, God scheduled property, the God deed. That deed, by that deed, they transfer a portion of that, retransferred to me.
Retransferred in favor of the plaintiff.
That is a suspicion. When, my lord, I told, my lord, and entered property by sale deed,
Now, what about the pleadings there? This is the pleadings. They have challenged this. They have not. They have denied all the things.
My lord,
Defendant has denied all the things.
denied all the things. Is that by free will I transferred it.
Now, what about the evidence action, witness action?
Witness, they failed to, my lord, produce because their claim is also there that
Plaintiff appeared before the dock.
And my lord says that I was under misrepresentation. I put the signature. I can only sign. I cannot understand the nature of the document.
What about other evidences?
Other evidences, my lord, they have on their part. They have.
No, on your part, on plaintiff's part.
I did not file any further. I did not.
So there are only PW1.
PW1.
There are no other PWs.
Oh, that is not the PW2 is not so much correlated. He was residing in the same premise.
PW2.
PW2.
Okay. So the circumstances,
another
circumstances of misrepresentation only pleaded and evidence was given by the plaintiff herself. Okay.
And because they have also filed a counterclaim saying that although these are
counterclaim is there.
Yes, counter.
Okay, counterclaim is there.
Here, my lord, 111 of your lordship knows that the evidence act. When the person having a good control over will of a person, the burden of proof will shift to that person.
No, that is altogether separate issue.
Legally,
I want to
yes.
know who are the evidences before the learned trial court. You have adduced only one evidence regarding the misrepresentation.
PW1 is plaintiff.
চেকআপ কাউন্টার কি আছে কি?
আচ্ছা এই জন্য তো ডিগ্রি
সেটা নেই তো সেই রকম
আপনার ডিফেন্সে এতে এরকম ডব্লিউ এতে Yes. To primary count. আচ্ছা তো count.
claim of the
counter claim was your counter.
decision file.
The WSC লেখা আদালত করতাম I stand corrected, my lord. On behalf of the plaintiff, four witnesses were. Four witnesses, PW4. P1, P2, P3, and P4.
So who are the evidences regarding misrepresentations? Okay, very well. Check it out. Check it out. I have started the hearing. So
Only, my lord, kindly excuse me on 13th, my lord.
If not 13, then not this year.
20th, not. No, I have.
Next week.
Please take down.
It may be fixed on any other day at your work.
No, it cannot be fixed. I have fixed only the second appeal in the Friday. Now there are some other determinations. Otherwise, they will run.
Then I'll make it part third, my lord.
Yes, I will make it part.
Then 24, 20th, 20th, then 20th.
I think lordship has something.
3rd of January. 3rd of January.
Subject to lordship. At consideration of the may it be fixed on 20th.
No, 20th is not be court would be not functioning.
Then let it be marked as parted.
Yes. Please take down. The matter is ready for hearing. Full stop. The argument started. Second appeal, hard in part. Let the matter fixed on 3rd of January 2025 for further hearing of the second appeal. under the heading part-heard matter. এখন আরেক মিনিট আছে, কে কি বলছে দেখে নি।
After recess, after recess, this matter, Mother Bhaskar Chandra Manna is appearing on behalf of the applicant matter.
You are appearing on behalf of the appellant?
I am for the response. Mr. Bhaskar Chandra Manna, he has not come to court, my lord. I am praying for not.
What about you to be appear on 13th? 13th. Okay, that's what the day. Second half তো ওটা আছে। ঠিক আছে।
Lordship has passed over item number 124. Lordship, it is
120?
124, your Lordship had passed over. 124 টা pass over ছিল না? No, আমি appellant.
You are for the?
Appellant.
Who is for the respondent?
He was here, my lord. He was just went, my lord. Probably, my lord, went outside now. Just now, my lord, Lordship is willing to
appear on 13th. 13th.
13th.
Appear on 13th. 13th.
Grateful.
আর বসবেন দাদা দাদা
typographical error. ঠিক আছে, ঠিক আছে, my lord, this matter has come at my instance for a small correction, my lord. My lord, kindly, with my lord's leave, I'll just mark the portion once. Page 40, page 41. My lord, paragraph 41, page 33. Lordship, the difficulty is, it's written here, till the issue be decided, the principal amount of rupees 10 lakhs payable. My lord, there has to be as on date. Principal amount was, my lord, 10 lakhs at the time of, my lord, in the year 2015. Now the registrar is, my lord.
I understand. Registered has.
Yes, Lord.
I understand. The registered has put in the
Yes, my lord. Short-term
short-term deposit scheme. So that was just earn some interest. You want this?
So grateful, your lordship. As on today, my lord, kindly makes it as on today. Registered would be, my lord, free to, my lord, disburse the amount. My lord, this is the
No, the what amount the registered has deposited? Registered
10 lakhs
deposited
of
10 lakhs plus.
plus the accrued, plus the, my lord, this is the justification that the registered has given us. Your lordship, kindly look at it. So should they has on date কথাটা add করে দিন তাহলে রেজিস্টারের টাকা ছাড়বে সকালে। My lord, the disputed portion is the interest portion. That is, my lord, 16 lakhs will be there.
Yes.
Only as
No,
on date,
what was deposited by the register? 19 lakh. 19 lakh.
33 lakhs.
Whatever may be, 19 lakh is the amount which was deposited by the register.
Yes, my lord.
Amongst which principal amount is the 10 lakh.
10 lakh.
So 10 lakh has
16 lakhs as on
accrued
date.
some interest.
Yes, my lord.
But the deposit has been made in respect of entire 19 lakhs.
Yes, my lord.
Okay.
Yes, my lord.
So the bank has to calculate how many amount was earned in respect of 10 lakh.
Registered as well, your lordship. Only as on date, 17 lakhs is there in terms of the principal amount of 10 lakh.
Okay.
And the remaining amount is will be there, that will be reinvested, and accordingly that will be decided by the large advance.
That has already been invested. That has already been invested. That is there in the account.
Yes, my lord. Only if my lord adds as on today, that will be, my lord, sufficient for the registered as well to act in terms of this order. As on date. And then that has been indicated by the registered as well. I mean, registered himself has said that this amount has become 17 lakhs as on date. my lord.
হ্যাঁ কিন্তু প্রিন্সিপাল অ্যামাউন্ট তো কোনো বদলাচ্ছেই না।
As on date. Okay.
Only as on date, your lordship, kindly. Next.
প্রিন্সিপাল অ্যামাউন্ট তো অ্যাজ অন ডেট। প্রিন্সিপাল অ্যামাউন্ট কত টাকা মানে 10 লাখ চলছে লেখা আছে 10 লাখ 10 লাখ দিতে পারবো। শর্ট টার্ম থেকে দেওয়া আছে না এটা কি 17 লাখ। আচ্ছা অ্যাজ অন ডেট যদি লেখা থাকে তো then they will subtract it.
Exactly.
Okay.
I'm not opposing.
This matter appears for correction. In paragraph number 41, the principal amount mentioned as rupees 10,20,721.49. 21,721.49
ইংরেজি তো কোনো মিনিং হবে না।
should be read as rupees 10,20,721.49 plus interest as on today.
My lord, will kindly add accrued interest, my lord, as on today.
We
If your
plus
lordship said
accrued
yes.
करो. Plus accrued interest as on today. Full stop. The department is directed to made out the correction in the impugned order. Full stop. Remaining portion of the order unchanged, unaltered.
Deeply obliged, my lord.
Yes.
Right up.
Yes, this matter will take at least half an hour and more. Thereafter, your matter will take an hour. I know, 3:30. Mr. Sirana will complete today. Okay.
I'll definitely try, my lord.
Yes.
Third sitting निकालो 11 number.
Yes, Mr. Sura.
Yesterday, my lord, I was making my submission on additional rent. More or less, I have completed that, but I did not specify certain minutes in support of my submissions. I'll just highlight those minutes. 53rd.
No,
Submission वाला कहाँ है वो? 53rd में ही है. 53rd sitting. Correspondent based on the said statement made before the learned tribunal for amendment of his claim. 11, volume 11. For amendment of claim which after considering the objections of the petitioner, the learned arbitrator was reluctant to grant such amendment. I'll just make some.
Yes, yes. You just start.
Correspondent number 1 based on the said statement paid before that statement is that additional license fee. Paid before the learned tribunal for amendment of this claim, which after considering the objections of the petitioner, the learned arbitrator was reluctant to grant such admission amendment to avoid further prolongation of the proceedings. It is submitted that refusal to grant such an amendment on such flimsy ground of prolongation of the proceedings by the learned arbitrator was not in conformity with the established settled principles of law. The arbitral proceedings continued for well over 14 months from 53rd sitting. As such, the ground taken by the learned arbitrator of prolongation of proceedings is erroneous and does not hold water. The learned arbitrator, however, concluded that since the documents were disclosed by the petitioner, who otherwise knew what was the issue at stake, no possible objection could have been made if the claimant respondent number 1 seeks to modify his claim on these two counts. And on this all point, I would rely on a judgment of Patna High Court, my lord. On the second page, my lord.
Yes.
Fifth line, my lord, of the class number 4. Thereafter, the plaintiff filed the petition for amendment and the same was allowed. The amendment sought for, in my view, does not change the nature of the suit and it is simply a consequential. As such, consequential relief can be added at any time before the delivery of the judgment in order to pass effective order, judgment, and resolving the disputes between the parties. So if I am to amend that claim, it should be accepted before the judgment is delivered.
Yes.
In 53rd and 54th sitting, held on 11th and 12th of March, what was stated here, Mila? Mr. Surana first proceeds with his argument on account of his claim for additional security and additional rent. His claim is pleaded in paragraph 42 and 43 of the statement of claim. But in course of argument, 1556, volume 11. One five five six. Just at the bottom, my lord.
53rd and 54th.
Yes, my lord.
Yes.
It was held on 11th and 12th of March, my lord. Mr. Surana first proceeds with his argument on account of his claim for additional security and additional rent. His claim is pleaded in paragraph 42 and 43 of the statement of claim. I wish to remind your lordship that in paragraph 43 of the statement of claim, those various shops, the names were indicated. So it was well in
30
the
shops are there. 30 shops are there.
30 shops. So it was in the knowledge of the learned arbitrator very much. But in course of argument, Mr. Surana seeks to make out a case for a larger sum in deviation of his original pleading. I suggested that in absence of the pleading for the said larger amount, I might not be able to entertain this said enhanced claim, regardless of the fact that he proceeded to make out a case on the basis of documents. To my suggestion, an amendment of the claim might be in order. Mr. Saha raised an objection saying that at that late stage, whether it would be right for me to permit such amendment is an important factor to be considered by the learned arbitrator. My tentative view is that since issues can be raised on the basis of documents disclosed, there should not be any real objection to permit the claimant to amend his claim, which would only be a matter of formality. So my amendment was on the basis of documents which were disclosed and were there on the arbitral proceedings. More so, since the documents in reliance on which the said claim has been sought to be made by the claimant were disclosed by the respondents themselves.
Yes.
So the respondents were aware of what is going to happen or what should happen. It may not be justified to prevent the claimant from making amendment of his claim. It's a very categorical finding here, Mila. At any rate, the basis of the claimant's claim for additional security and additional rent is to be found primarily in the supplementary agreement made between the claimant and Pantaloon Retail on 14th of June. which modified the clause 17 of the original agreement by providing the pantaloon would be entitled to further sublicense 30,000 square feet of area to third parties. Mr. Surana says that it was agreed in course of discussions which preceded execution of the said supplementary agreement that in consideration of such permission to sublease, pantaloon would be obliged to make over additional security and additional rent to the claimant. Why I am submitting it, my lord? Mr. Mukherjee has made a submission while making his case that Mr. Surana is referring to certain documents which were executed before execution of the supplementary agreement. Now, supplementary agreement was executed on 14th of June 2008.
Yes.
And the email which was sent by the regional head of Eastern region was on 13th of May. So I have submitted before the tribunal that it was discussed before execution. So it is all duly recorded here. It's not that I'm making a submission today. It all has been discussed in detail, my lord. That in consideration of such permission to sublease, pantaloon would be obliged to make over additional security and additional rent to claimant. This arrangement of agreement was apparent from the conduct of the parties as well as from the email of the respondent dated 13th of May. And also a letter dated 27th of February of the respondents. That is at page 1179, my lord. I placed yesterday, my lord. Then I'll come to 53rd and 54th sitting, my lord. Then again, further, my lord. Mr. Surana contends. On 1558, my lord, at page 1558.
Yes.
Paragraph 2nd, my lord. Mr. Surana contends that neither the respondent gave such prior permission, such prior intimation to the claimant before execution of the agreement of the sublicense entered into by the respondents pursuant to such permission, nor the respondents provided copies of actual sublicenses at any stage. Hence, the claimant's claim, as pleaded in paragraph 42 and 43 of the statement of claim, was virtually shot in the dark based on pure guesswork. But now, when the respondents themselves have disclosed 3 sublicense agreements made by the respondent, the claimant is in a better position to form his claim with some degree of precision. Taking the average of rent and security deposit as recorded in the set 3 sublicense agreements, Mr. Surana has worked out his revised claim as reflected in the chart flagged today. Now that chart was taken on record without any objection.
The least.
That is statement of based on average rent.
Yes.
3 disclosures. That is recorded in 53rd and 54th sitting, my lord. It appears from the said chart that the claimant is entitled to a sum of rupees 97,66,224 towards the security deposit and a further sum of rupees 7,71,83,184 towards license fee, in contrast to his originally paid claim of rupees 50,000 and 3.95 crores in paragraph 42, 43 and 50 at serial number 25 of SOC. Mr. Surana claims to have made innumerable demands asking the respondents for additional rent and additional security deposit, which would appear from the document at pages so and so, so and so. Now, I have submitted before your lordship yesterday.
Yes.
I continued hammering them, give me these documents, give me these documents, give me the additional rent, give me the security. They never gave me. Now, these letters are, some of the letters are there, some of the emails are there.
Yes.
Should I place those?
Not necessary. You have shown something to me.
The claimant respondent number 1, based on the said documents prayed before the learned tribunal for amendment of his claim, which after considering the objection of the petitioner, the learned arbitrator was reluctant to grant such amendment to avoid further prolongation of the proceedings. It is submitted that refusal to grant such an amendment on the flimsy ground of prolongation of the proceedings by the learned arbitrator was not in conformity with the established settled principles of law. The arbitral proceedings continued for well over 14 months, my lord, thereafter. Now, the petitioner, by committing breach of the terms of the supplementary agreement dated from 14th of June 2008 and by neither giving any prior permission before execution of any agreement with the sub-license nor providing copies of the same, even after various reminders, compelled the claimant, that is the respondent number 1, on the basis of disclosure of documents made by the petitioner in the arbitral proceedings to seek an amendment of his statement of claim in respect of additional monthly license fee over and above rupees 1950 per square feet and security deposit payable by such subsequent licensees and interest thereon. It is submitted that it is settled principle of law that such amendment should have been allowed by the arbitrator due to the fact that the original respondents were fully aware of their liability, which was not a new claim. And I have cited those Supreme Court judgments before your lordship and the Patna High Court judgment also, yes, today. The learned arbitrator had duly come to such finding. The learned arbitrator was fully aware of the settled principles of law and as such had clearly stated in paragraph 74 of the award. It was only at very late stage of proceedings, which 53rd sitting held on 11th March 2015, that Mr. Surana proceeded to claim much larger sum on each account on the basis of that the respondents withheld all the sub-license agreements from the claimant until recently when they disclosed only 3 such sub-licenses. Mr. Surana prayed for amendment of his claim, which after considering the objection of counsel, I was reluctant to grant to avoid further prolongation of the proceedings. So my humble submission, my lord, if there is a legal lacuna, if there is a legal bar in not accepting that, that is one issue. Here, the documents were disclosed by the petitioner themselves. They were aware of their liability. I just wanted to amend my claim based on those documents. That should have been allowed, whether the arbitration prolongs or does not prolong.
Yes.
From such finding, it is very clear. I opine that since documents were disclosed by the respondents and who otherwise knew what was the issue at stake, no possible objection could be made if the claimant seeks to modify his claims on these 2 grounds. This is what the learned arbitrator has stated in the minute mirror. So the learned arbitrator had no issue, had no problem in revising my statement of claim. But only on account of prolongation, it was not. And prolongation is not a legal bar.
Yes.
From such finding, it is very clear that there could not have been any possible objection by the respondents to such amendment of claim in respect of additional license fee and security deposit. Yet the learned arbitrator were to disallow such amendment of claim of the claimant on frivolous ground of prolongation of proceedings, which is clearly inconsistent to his own finding and thereby committing a manifest error. The learned arbitrator was required to have overruled such flimsy objections of the respondents and should have accepted the amended claim of the claimant on this ground. The respondent number 1, I submit that prolongation of proceeding cannot be termed as a legally acceptable ground for not allowing the statement of amendment of claim as sought by the claimant for additional license fee and security deposit and interest thereon which otherwise was accepted by the learned tribunal. Now, my lord, when the petitioner was making his submission, Mr. Mukherjee has submitted that there was no amendment of the agreement. And clause 43 requires amendment, that every amendment has to be in writing. Now, this ground was not taken before the learned arbitrator. If this ground was not taken before the learned arbitrator, they are barred from raising this issue today.
Okay.
Another, my lord, another important issue, my lord, my evidence has neither been contradicted by the petitioner nor there has been any cross-examination.
Your evidence.
My evidence. I mean, if I claim 100 rupees and if there is an evidence of mine or my witness and if it is not contradicted or if it is not cross-examined, that remains, my claim remains.
Yes.
I rely on a judgment B. Page 110. 110. P. P 110. My lord, it is a very famous judgment. I'm pretty sure your lordship is fully aware of this judgment, my lord. It is still followed everywhere, my lord.
Yes.
I rely on paragraph 10 of this judgment, my lord, which is at page 112, B 112, my lord.
Yes, proceed.
The law is clear on the subject. Wherever the opponent has declined to avail himself of the opportunity to put his essential and material case in cross-examination, it must follow that he believed that the testimony given could not be disputed at all. It is wrong to think that this is merely a technical rule of evidence. It is a rule of essential justice. It serves to prevent surprise at trial and miscarriage of justice, because it gives notice to the other side of the actual case that is going to be made when the turn of the party on whose behalf the cross-examination is being made comes to give and lead evidence by producing witness. It has been stated on high authority of the House of Lords that this much a counsel is bound to do when cross-examining, that he must put to each of his opponent's witness in turn so much of his own case as concerns that particular witness or in which that witness had any share. If he asks no questions with regard to this, then he must be taken to accept the plaintiff's account in its entirety.
Yes.
Such failure leads to miscarriage of justice. First by springing surprise upon the party when he has finished the evidence of his witnesses, and when he has no further chance to meet the new case made which was never put, and secondly, because such subsequent testimony has no chance of being tested and corroborated. Next page, my lord, paragraph 11. On this point, the most important and decisive authority is Brown versus Dunn, reported in 1893, 6 R67. It is a decision of the House of Lords, where Lords Herschel, Elsie, Lord Halsbury, Lord Morris, and Lord Brown were all unanimous on this particular point. Lord Chancellor Herschel, at page 70 of the report, observed. Now, my lords, I cannot help saying that it seems to me to be absolutely essential to the proper conduct of a course of a cause where it is intended to suggest that a witness is not speaking the truth on a particular point, to direct his attention to the fact by some questions put in cross-examination, showing that that imputation is intended to be made and not to take his advice and pass it by a matter altogether unchallenged, and then when it is impossible for him to explain, as perhaps he might have been able to do if such question had been put to him.
Yes.
The circumstances which it is suggested indicates that the story he tells ought not to be believed, to argue that he is a witness unworthy of credit. My lords, I have always understood that if you intend to impeach a witness, you are bound, whilst he is in the box, to give him an opportunity of making any explanation which is open to him. And as it seems to me that that is not only a rule of professional practice in the conduct of a case, but is essential to fair play and fair dealing with witnesses. Paragraph 12. My lords, with regard to the manner in which the evidence was given in this case, I cannot too heartily express my concurrence with the Lord Chancellor as to the mode in which a trial should be conducted. To my mind, nothing would be more absolutely unjust than not to cross-examine witness upon evidence when they have given, so as to give them notice and to give them an opportunity of explanation and an opportunity very often to defend their own character, and not having given them such an opportunity, to ask the jury afterwards to disbelieve what they have said, although not one question has been directed either to their credit or to the accuracy of the facts they have deposed to. 13, the small one. My lords, it seems to me that it would be a perfect outrage and violation of the proper conduct of a case at nisi prius if, after the learned counsel had declined to cross-examine the witness upon the evidence, it is not to be taken as a fact that that witness did complain of the plaintiff's proceedings, that he did receive advice, that he went round to Mr. Dunn as a solicitor, and that he did not sign that retainer. The whole case on the other side, being that of the retainer, was a mere counterfeit proceeding and not a genuine retainer at all. Case 100. Case 100. The learned arbitrator has also stated in the award that there is no cross-examination, and my evidence was taken. It was not disputed at all.
Yes.
It has been there in the arbitral record. And my lord, this has also been carried on by another bench of this honorable court, which is at page 124, my lord. Mitesh Mehta versus Saregama India Limited. Page 124. B.
Yes.
I have referred to paragraph 7, my lord. I'll read from 6th line, my lord. Can I place it, my lord?
Yes.
AEZ Karapit and Johari Shah are relevant on the point of the arbitrator's finding that the petitioner choose not to lead corroborating the statements made in the affidavit of evidence or produce his witness for cross-examination, and also did not cross-examine the witness of the respondent claimant in respect of the money claim of the petitioner. Both the decisions are an extension of the principle of Order 8, Rule 5 of the Code of Civil CPC, and lay down the circumstances when an opponent will be taken to accept the evidence led by the other party. In other words, non-denial of an allegation of fact would presume admission of fact. On the other hand, the reliance placed on ONGC versus pipes will have to be seen in the context of later pronouncement of the law in associate builders with reference to section 28 of the Act, and would have been relevant if the arbitrator had made a conscious departure from the terms of the contract, which is not the case here. It is settled law that interpretation of the terms of contract is within the domain of the arbitrator. With reference to so-and-so, the proposition of law that an award can only be interfered with if found to be perverse or contrary to the evidence or against public policy cannot be called to question. This decision would have been of assistance to the petitioner if the finding of the arbitrator had been perverse or contrary to the evidence before him. Now, as far as award made by the learned arbitrator is concerned, he has looked into every document. He had given equal opportunity to the other side also, to me also. They have said their things, I have said my things. Ultimately, he has come to the conclusion that this amendment of claim which Surana is giving is based on the documents disclosed by the respondent, by the petitioner. So there should not be any objection. That should have been accepted. Non-acceptance is a perverse act.
Yeah.
This is as far as, my lord, the additional license fee is concerned. And as far as the cases are concerned, your lordship has said, I will make a small note and indicate all those things. I have stated, just for your honor reference, I would say another two judgments were also there. State of UP versus Allied Construction, which is there in the list, my lord. S. Harcharan Sino versus Union of India 19904 SCC 647. Rajasthan State Mines and Minerals versus the State versus Eastern Engineering Enterprises. Oriental Insurance versus Diamond Products. Ispat Engineering and Foundry versus SAIL. BOC India Limited versus Bhagwati Oxygen Limited. It is there in the list also. Few of them is not there. I'll produce them. And they all deal with the fact which I have submitted before us. And I hope this chart is with your lordship.
Yes, it is with me.
And this is very clear, my lord. Now, my lord, there are small claims on account of water charges. There are two claims. One is water charges, one is electricity charge. The petitioner has said that the learned arbitrator has awarded the claim under section 70 of the Contract Act.
Yes.
Hence, this is not tenable. This is untrue, my lord.
Electric charges is 14,16,000 like that, and water charges 11,70,000 like that.
Yes. So They have submitted that this claim has been admitted under section 70 of the contract. It is not a fact. There are provisions in the contract that I am entitled for water charges. There are provisions in the contract that I am entitled for electricity charges. I'll place that before your lordship. Page 116 of Arso Vice. Second, part 2. One month 6. Not A Roman 3.
Yes.
Page 116. Lordship got it?
Yes.
Now, Roman 3 says the license fee shall be exclusive of maintenance charges and outgoings, recurring expenses, taxes, electricity, and water charges. So, my license fee is exclusive of electricity charges and water charges. If I supply them electricity, I'm entitled for the electricity charges. If I supply them water, I'm entitled to the water charges. And whenever I have supplied them, I have claimed to certain extent it has been admitted, to certain extent it has not been admitted. So their claim that it is admitted under section 70 of the Contract Act is perhaps not true.
It is within the agreement.
It is within the agreement. No, 5. $665.
Yes.
They have challenged this claim, my lord, under paragraph 40 SS 2 UU. This is their petition. Section 31.
Okay.
Now, the respondent number 1 denies the allegations made by the petitioner in paragraph so and so of their petition filed on 17th of August 2016. There is no jurisdictional error committed by the learned arbitrator as wrongly alleged by the petitioner. There is clear provision in the agreement which I have just placed before your lordship. The respondent number 1 states that the learned arbitrator has correctly made an award for payment of water charges at the rate of rupees 30,000 per month. How he has, I will come to. Upon thorough evaluation of the evidence of the parties for demand and supply of water, as also water supply charges by other agencies, correctly following the provisions of the agreement contained in so and so. The claim of the respondent number 1 and award thereof by the learned arbitrator is sufficiently documented and well within the parameters of the agreement. The learned arbitrator has come to a finding that the supply of water by the respondent number 1 has not been denied by the petitioner, as is apparent from the emails as page 665, volume 5. Page 665, Mila. Now, there are various emails here, Mila.
Yes.
The last one is, this is to inform you that the main borewell submersible pump supply cable has been short-circuited and burnt. Spoken to Mr. Surana and his site engineer, Mr. N.K. Ghosh, to do the needful on war footing. According to them, their engineer will be arriving tomorrow. Told to site engineer to provide alternate provisions for water storage from municipal corporation, as I have only 20% water left. That is what they have said. My reply was, very small. From the builder side, they have raised
their hands.
Saying it will be done only tomorrow. So what I wanted to say, Milord, that their requirement was water was there. And their requirement was something around 30,000 liters a day. It's an area of 1,15,000 square feet which have been sublicensed to them, and it is centrally air conditioned. Now, this centrally air conditioning has been done by Voltas Limited. It is a water cooler chiller, and water cooler chiller needs certain amount of water.
Yes.
And that requirement was 30,000 liters a day. That is, they have stated in that. If your lordship could kindly come to page 684, my lord.
Yes.
This is an email from their Arijit Chatterjee, who was the mall manager there, my lord. Only one boarding is existed in the entire premises, which is run by a submersible pump, which is not working today for some underground electrical fault. There is no alternative arrangement for supplying the water for the essential for the entire mall. If water supply stops, then we will not be able to run the chillers for the mall. We required a backup boring for supply of the water to our storage tank. There is another alternative solution which is already been exists at the premises. A direct railway supply line is there, and supply is on for the round the clock. If builder can modify the same, then that water can be used for drinking purposes. My lord, this is a railway premises which has been leased out to me. The railway has never agreed to supply me water. The railway has never agreed to supply me the required amount of electricity for running the mall. So if that is to be needed, it can only be for what? Drinking purposes, my lord. It cannot run the chiller. 30,000 liters cannot be supplied even by railway also.
Yes.
I had spoken to the fire brigade people, but they have got capacity of 4,200 liter tanker, and our daily consumption is 30,000 liters. This is their statement, my lord. Which is impossible for them to supply in emergency also. If we call the corporation water tank, then they will not be able to reach to the storage tanks, since there is no proper road or path. $685, my lord. 685 our place. $685 is from one of their another senior officer from Bombay. Now he says, I would therefore request you to arrange for an alternative. The options are as follows. There is a water supply line running the premises, which belongs to railway. With your kind initiatives, I am sure the tappings can be taken for the mall, which will solve the issue forever. Second option is to have another borewell, which will be handy in case of failure of one borewell or while doing preventive maintenance. They all want services. They don't want to pay. This was issued in the year 2008, my lord, 10th September. And they have never paid me. They were in use since 1st of October 2007, when hundreds of their workers were working for fit-outs. 686, my lord, another. The same thing is being repeated over here, my lord. The petitioner's average daily consumption is 30,000 liters of water, has also been examined by the learned arbitrator based on the emails and its attachment sent by the petitioner to correspondent number 1 on 4th of September is 563 to 567. Volume 4.
Volume 4. Five, six.
Yes.
I mean, Lord, this is the mail sent by the person who was maintaining the mall, my lord. There are 3 attachments over here, my lord. If a lordship could kindly come to the next page, it gives an indication of the consumption of water. 564, my lord. 564, 565, 566, 567. And everywhere they are saying their requirement is 29,000 liters, 30,000 liters, 28,000 liters, like that.
Yes.
Before I proceed further, let me place the award before your lordship. This is at page 89, my lord, of 822, volume 1. Paragraph 58, my lord.
Yes.
Can I place it, my lord?
Yes.
This claim has been plated in paragraph 13, 20, and 40 of the statement of claim. Reliance has been placed on the provisions of clause A3 and clause 2. A3, which I have just placed before your lordship, my lord. And this is again there in clause 2 also, my lord, of the agreement providing contractual basis for such claim. Now, my lord, the arbitrator is fully aware of the fact that there is a contractual relationship for supply of water and payment there. It's not that he was not aware. Undoubtedly, there is a general reference in the aforesaid contractual provisions for enabling the claimant to make a claim on this account, but I do not find any dispute or clear provisions in the agreement which entitles the claimant to make such claim as such. Nor any basis has been laid down as to how and in what manner such water charges are to be worked out and paid by the respondents as sublicense. 59. The claim for water charges appears to be made on the ground that water to the complex has been provided by him alone. The position has not been denied by the respondent, as is apparent from the various emails dated 4th September, 9th September, 1st August, which are there at page 665 to 667 of the volume 5 I have just placed before your lordship, my lord. In fact, it appears from the attachment of emails dated 4th September of the respondent's address to the claimant that the total daily consumption is 30,000 liters on an average. In absence of any specific provisions in the agreement for claiming water charges, the claimant has based his claim on a quasi-contract under Section 70 of the Indian Contract Act as a provider of water to the respondents. Having regard to the wide amplitude of arbitration agreement contained in clause 41 of the agreement. Now, 41 is the clause for arbitration clause, my lord.
Yes.
Where it is said all dispute.
All dispute arising between the parties.
Of the agreement, which includes all disputes relating to or connected with the scheduled premises, the dispute over water charges is covered within the reference. So the dispute is covered within the reference. The claimant contained that the entire infrastructure for the purposes of ensuring water supply, including borewell, underground reservoir, overhead tank, laying of supply lines, installation of pump, water treatment plant, has been provided by him at his own cost, and the respondents have enjoyed the benefit of it. According to the claimant, the estimated cost of these must be not less than rupees 30 lakhs. I have placed all the documents. But I have to make an underground water reservoir for 2 lakh liters of water. Otherwise, I would not have been allowed to run the ship. This was half of that for the mall, half of was required for firefighting services. It was further contended that the respondents had enjoyed and water continued to and were continuing to enjoy the benefits of those infrastructure during the entire period of stay, and hence the claimant is entitled to be compensated for the same. It was also contended that Kharagpur municipality at material time charged rupees 300 per 1,000 per. I mean, this is the letter issued by Kharagpur municipality where they say that we will charge 300 rupees for one container which will carry 1,000 liters.
Yes.
So this required around 30 containers, means around 9,000 rupees a day. 9,000 rupees a day according to this method. And on the basis of estimated the consumption referred to above, the claimant is entitled to a claim of rupees 3 lakh per month from the respondent. This is perhaps a wrong calculation, Milord. It should be less than this.
Yes.
However, the claimant has made a very modest claim in the sum of rupees 30,000 per month. What I have stated, I have invested around rupees 30 lakhs for this infrastructure, underground cable, laying of lines, pumps, overhead tanks, and everything. All this I have spent around 13 lakhs. So I said, let me be given at least 1% of my investment. That comes to 30,000, and which was admitted by the learned arbitrator and which has been allowed. However, the claimant has made a very modest claim of rupees 30,000 per month by way of compensation for the benefit conferred on and enjoyed by the respondents. Accordingly, I award a sum of rupees 11,70,000 for the period of 39 months at the rate of rupees 30,000 per month by way of compensation for the benefit received by the respondent. My humble submission is this 39 months the tribunal has calculated from the date of commencement to the termination.
Yes.
My humble submission is I'm entitled from 1st of October when I have given them the possession for fit outs. When hundreds, around some 500 people were working for the fit outs. And leaving that aside, why it should be considered only up to the date of termination? When a license fee is being given to me for 5 years, lock-in period, which is up to July 2013, at least it should have been considered for that period,
that lock-in period.
And not that they remained in wrongful occupation of the premises. As on the date of publication of the award on 19th of May 2016, they were still in occupation of the premises. So I firmly submit that I am entitled under the award at least up to the date of publication of the award.
Yes.
The learned arbitrator on account of water charges is awarded a sum of rupees 11,70,000 million, payable at the rate of 30,000 per month for 39 months from August 2008 to October 2011 million. Whereas the petitioner has been consuming supply of water right from October 2007, when the possession of the demised premises was delivered to them for fit outs million. Petitioner's consumption of water between October 2007 and August 2008 was even higher due to large number of contractors and workers employed by the petitioner in its fit-out works. The monthly water charges have been arrived at by the learned arbitrator considering the documents on the arbitral record and evidence led by the respondent number 1 in order to meet petitioner's use requirement of water supply duly considering the alternate charges which would otherwise have been paid by the petitioner. The learned arbitrator has concluded that the claim for water charges made by the respondent number 1 is very modest, recorded in paragraph 59 of the award at running page 151, 152 of the petition. However, since the petitioner has been in an uninterrupted occupation of the premises right from October 2007 and have not vacated the premises till the date of making of the award, even upon issue of Allah's letter of termination on 31st October 2011, effective forthwith, and also despite consent degree of eviction passed on 8th of April 2013, that is the interim award, my lord. The respondent number 1 is entitled for further payment of water charges for 65 months at the rate of rupees 30,000 per month, that is 19,50,000 from October 2007 to July 2008, that is 10 months, and from November 2011 to May 2016, 55 months. Thus, the respondent is entitled for a total sum of rupees 31,20,000. 11,70,000 has been allowed. I am entitled for another 19,50,000 because they have been consuming water. I have been providing them. And the funniest part is, my lord, not even a single pipe was paid. Had I stopped supply of water, the entire mall would have been closed. I did not do that, my lord. I wanted, let them grow. If they grow, I will also grow. I am of that nature, my lord. The Honorable Madras High Court in Hindustan Petroleum Corporation versus Banu Construction at page 8265. Among the judgments, at page 265, my lord, the 9th line, my lord. This is the judgment delivered by Madras High Court, my lord, where our Honorable Justice Sanjeev Banerjee was there as Chief Justice there.
Yes.
And it has been stated in the judgment, my lord, Section 34 of the Act provides for a supervisory jurisdiction to correct manifest error and to ensure that there is no grave miscarriage of justice. I leave it to your lordship whether it is manifest error or not. And for supervisory power, my lord, I have also referred a judgment of quality.
Yes.
And I have also referred the judgment of McDermott.
Yes.
That is also there, my lord. And here also I have cited various judgments like Associated Builders, Sumitomo, Sudarshan Trading, Steel Authority versus Gupta Brothers, MMTC versus Vedanta, Tamil Nadu Civil, Albert and Navodaya Mass Internet. The main thing is that once the arbitrator has applied his mind to the matter before him, the court cannot reappraise the matter as if it were an appeal, and even if two views are possible, the view taken by the arbitrator would prevail. The next is, my lord, electricity charges. Here again, the arbitrator has said that he is passing the award under section 70 of the Act, but he has admitted that there is wide scope in the agreement, and I have placed before your lordship A3, I am entitled for electricity charges when I supply them. My lord, as far as this electricity charges is concerned, let me clarify one thing. Here again, they have wanted to mislead the arbitrator. that Mr. Swarana did not receive the supply of electricity, how did he claim electricity charges from him? It's a fact, I did not receive the power to run the mall. But I requested railways that as long as I do not receive the supply of power, give me certain amount of power so that I can run my borewell, I can run my emergency services. They agreed and they provided me a single phase line of 5 watt and a 3-phase line of 15 watt. They provided me that. Okay. And that was used for these purposes. And when it was used for the benefit of the petitioner, I am entitled for such charges. Now, whatever charges the railway have claimed from me, they have provided me the documents. I have annexed these documents in the arbitral proceedings. Those documents were duly verified by the petitioner. They have agreed. There are emails on the record that we must pay this. It has not yet been paid. But here this award definitely contains a manifest error, which your lordship will definitely correct me, Lord. I'll come to that. Respondent number 1 obtained an ad hoc supply, electric supply connection with the railway on payment basis to run borewell and other emergency requirements, including petitioner's requirement of electricity charges for fit outs from 2007 to 2008. Let me place before the award, will not before your lordship. This paragraph 50 of the award, my lord.
Yes.
Electricity charges. Supply of electricity from WPSCTCL could not be brought on the premises for various reasons. I have submitted to your lordship. But claim on account of supply of electricity related to operation of borewell through power supply obtained from railway and energy charges paid by the claimant to the railway administration. As such, supply of electricity was arranged to be provided by the claimant at the request of the respondent is apparent from email dated 27th of February 2008, which is there at page 573 of volume 4. This was an email issued by the petitioner to me, Mila, when the fit out works was going on. The bottom portion of the mail is, please also note that when our all vendors starts work, we will be needing extra minimum 50 kilowatt construction power. We will reimburse you the cost of on presentation of the bill. So this is a clear acceptance that when I supply them power, they will pay me the charges for that.
Yes.
By the said email, the respondents made promise to reimburse the claimant the cost on production of bill. The claim on the account has been made in accordance with the provisions of section 70 of the Contract Act, where a person lawfully does anything for the person or deliver anything him, not intending to do so graciously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect thereof, or to restore the things so done or delivered. This is section 70 of the contract.
Yes.
But the arbitrator was fully aware of the fact that there are provisions in the contract for payment of electricity charges. And when such clauses are there in the agreement, this should not have been resorted to. But anyway, it was his jurisdiction. Whatever has been done, I am to place it before your lordship. A sum of rupees 9,88,762 has been made by the claimant as the total claim on account of supply of electricity by the railways as detailed in paragraph 40 of the statement of claim, read with annexure F at page 41 thereof. Real basis of the claim is really not found on the provisions of clause A3, C2 and A10 of the agreement, but is reflective of some makeshift arrangement between the railway and the claimant, or for the benefit of both the claimant and the respondents. The breakup of the said sum of rupees 9,88,000 consists of mere enumeration of bills from this month of October 2007 to December 2009 as set out at page 63 of the rejoinder. Such liability has been admitted by the respondent by the email dated 18th of August sent by PRIL in reply to the claimant's email dated 16th of August, both appearing at annexure E, page 64 of rejoinder. Volume 2, page 214. and 214. Well, 213 contains the various bills mailed to me by the railways, of which I have made the payment.
Yes.
All these bills were examined by them. And then they sent me a mail. The energy charges, next page, 214. The energy charges details sent to you were thoroughly verified with the railways demands raised for supply of power to Puja complex by Mr. Arijit Chatterjee on August 15, 2011. You are requested to release the payment as per details sent to you at the earliest.
Yes.
It was issued by the respondents to me, Milord. Here they have stated that their representative has inspected, verified all the bills of the railways, was satisfied, and then it was decided that they must make the payment of it. And that payment is yet to be received by me. And this email is of 2011, Milord. Mail of 2011. '53, Milord, paragraph 53 at page 31 of the award. Based on all these details referred to above at page 63 of the rejoinder, the claimant has made an additional claim at the rate of rupees 40,000 per month for a further period of from November 10 to May 2012, covering 19 months for an aggregate sum of rupees 7,60,000. Now, the subsequent bills were not verified by them. So I have said these bills are there. They are in regular consuming the supply of power. Let us come to an average of this. So learned arbitrator has come to a conclusion that yes, it is absolutely right. We should come to an average. Average was 40,000 arrived at.
Yes. 40,000 per month.
Per month. So based on all these details referred to above at page 63 of the rejoinder, the claimant has made an additional claim at the rate of rupees 40,000 per month for a further period of November 10 to May 2012, covering 19 months for an aggregate sum of rupees 7,60,000. It has been allowed. Demands in respect of non-payment of electricity charges were made by the emails dated so-and-so and letter number so-and-so, email so-and-so, so-and-so. Yet no reply to any of those letters and or emails were received from the respondents, which demonstrate such arrangement and admission of liability by the respondents. Should I place these emails, Your Lordship?
No, not necessary.
Since the agreement was terminated on 31st October 2011, in my view, the claimant would be entitled to a sum of rupees 14,68,762. That is 988 plus 4,80,000 calculated at the rate of 40,000 per month for a period covering from November 2010 till October 31, that is 12 months. Now, there is a slight mistake here, my lord. This period should have been from January, because here earlier he has given me up to December 2011, 2010, and then it should be from January itself, my lord.
Yes.
So those 10 months are to be added here, my lord. Since the agreement was terminated so and so, in my view, the claimant is entitled for so and so per month for a period covering from November 2010. It should be from January 2010, because earlier it has been accepted up to December 9. In my view, the said claim is in the nature of quasi-contract, and it is within the terms of the reference, having regard to wide ambit of arbitration clause so and so. My humble submission is that the learned arbitrator has calculated payment of electricity charges up to the date of termination of the contract. But then they have been using my electricity even beyond that. This is an national services. I could not disconnect the line. I did not disconnect it. And they were consuming the power right up to the date of publication of the order. Now, if the learned arbitrator has come to a conclusion that Mr. Surana is entitled for 40,000 average per month, it should have been considered at least up to the date of publication of the order, or at least up to the lock-in period. The supply of water and supply of electricity is an essential aspect, which if someone is consuming, they should honestly pay. Let us not dispute about it. It should have been paid, my lord. So my humble submission before your lordship is that I am entitled for electricity charges and water charges right up to the date of publication of the award. And the rate of water charges at the rate of 30,000 per month has been assessed by the honorable arbitrator. And the rate of electricity charges at the rate of 40,000 has been admitted by the learned arbitrator. So I am entitled for that at the publication of the award. And the 10 months, I hope your lordship is clear about that period, my lord. That's definitely a manifest error, my lord. Yes. And the same judgments which I have placed before in respect of water charges, the same set of judgments are there in respect of electricity charges also. The last claim is for extra worksmen.
Yes.
My lord, I have delivered them the possession of the premises of fit out on 1st of October 2007. Volume 3. Page 363.
Yes.
Page 363, this is a letter issued by me to the petitioner on 5th of September 2007. And I write in terms of clause 30 of the agreement to sub-license dated 30th of January 2007, executed between us, we are pleased to offer you possession of the premises being Block B at Puja Complex, Kharagpur, sub-licensed to you for fit-outs. The free fit-out period is 120 days from the date of your taking possession of the premises upon inspection. We request you to kindly arrange an early inspection and take possession of the premises for fit-outs in terms of the aforesaid agreement. The next page, my lord. 364. They conduct the inspection, my lord, and then they write, this is to put on record that in terms of and within the meaning of agreement executed between you and our company on 30th day of January 2007, we will take rent-free possession of the concerned property at Kharagpur Puja Mall on first day of October 2007 for commencement of fit-out works therein. Please arrange accordingly and inform. So the earlier letter was my offer. The second letter that we have inspected and we will take possession on 1st of October. And the next letter is possession, my lord. 365. This letter is signed by both the parties, my lord.
Yes.
We, Pantaloon Retail India Limited, confirm having taken vacant and peaceful possession of the premises being Block B at Puja, the Mega Mall, at Kharagpur on this day of 1st October, comprising ground, first and second floor for rent-free fit-outs in terms of agreement executed between Mahavir Construction and Pantaloon Retail on 30th of January. So, my lord, the petitioner is fully aware how a possession is taken and how a possession is delivered.
Yes. Yes.
The now, my lord, this premises was constructed as per their plan. They have supplied me plans that Mr. Surana, you construct like this. I have constructed according to their plans.
Okay.
And delivered the possession upon inspection. After taking, they wanted certain modifications. I have said if you want any modification, you have to pay for that. I cannot provide you free service. They agreed, yes, Mr. Surana, we will pay you. Whatever is cost, don't take any profit. We will pay you the cost. I said, agreed. I don't want any profit. My profit is included in my rent only. And for this small work, I don't insist for any profit. But actual payment, actual cost you have to pay. They agree with that. And this is in respect of various works which have been undertaken by me as per their instructions.
Yes.
And that comes to around 67 lakhs. Out of that 67 lakhs, they have paid me 20 lakhs. And 47 lakhs has not been paid. Now, I have submitted my claim giving all the details. I'll place it before your lordship. I, on account of extra works executed as per discussions with the petitioner, correctly following the agreement terms, being clause E38. There's a provision in agreement also at E38, my lord, that I can do this. This is 822 volume 2 is 126.
Agreement.
paragraph 38, my lord.
Yes.
The sub-licensee has inspected the plans and have approved the said plan of the scheduled premises, including the facade of the premises, and the entire designing of the building has been done keeping in mind the requirements of the sub-licensee. I just placed before your lordship that I constructed the premises as per their plans. They have confirmed here in the agreement also. However, notwithstanding the above, the sub-licensee shall be entitled to seek such changes as may be thought necessary. So there is an agreement, my lord. If they want certain amount of modification, I will carry it out. But then I have said that once I have delivered the position, you have inspected in terms of the agreement. If you want any modification, you have to pay for that modification. They agreed to that. I, on account of extra work executed as per directions of the petitioner correctly following the agreement terms being clause E31. The aforesaid sum of rupees 38,42,000 consists of first 12 items in annexure C. Annexure C निकालो statement of claim का. Annexed with the statement of claim as paid, एक number volume में. एक number volume, page 38.
This is the extra work. This is the extra work.
This is the extra work, madam. I have annexed the statement along with my statement of claim, my lord, which is at page 38. This is annexure C, my lord.
Yes.
And I write from item number 1 to 20. Now, in short, my lord, I will submit that from item number 1 to 12, the amount has been admitted by the learned arbitrator on their concurrence. The
1 to 12.
petitioner, 1 to 12. I will place all those documents before your lordship, my lord, on the next day. What I wanted to humbly submit is that from item number 1 to 12 has been allowed by the learned arbitrator on their concurrence. That yes, they should be paid. And then from item number 12 to 20, there has been a dispute, which I'll explain before your lordship. There is no dispute from my side. All the rates were admitted by them and they are entitled, they are liable to make the payment.
Okay, today that's
You know, on the next day, I will complete this extra works. This is the last claim which they have challenged, and then there are 3-4 claims admitted by the arbitrator, which will not take much of a time except one claim. I will complete that.
argument on behalf of Mr. Surana Hardin part. Let the matter appear in the list.
सबमिट किया था ना.
अच्छा ये सब वही है. Thank you.
बोल रहे थे ना रामचंद्र का कमिश्नर का जो ये प्लेस नहीं किया जब प्लेस
Next Friday. Next Friday at around. Thursday.
दिए जो नोट्स देंगे उसकी कॉपी हम आपको नहीं थे
दिए क्यों
नहीं
13.
नेट्स कुछ नहीं है क्यों जो जजमेंट्स हैं
Friday.
Next Friday, my lord.
Next Thursday, this matter, Mr. Sakkosen is there. He is arguing on this matter. This matter
is on Friday or Saturday?
Friday.
It was Friday or Thursday.
I have noted it as Friday, but I might be mistaken.
No, it was given Friday only 13.
Friday?
Check.
Okay. Good. ठीक है.
Or both matters can appear on the same date.
Yes,
So
yes,
this one can
Friday.
be given priority, no
Very well.
difficulty.
So it is not on Thursday, my lord?
Friday.
Friday.
On Friday.
Friday. Next matter to go.
Grateful, my lord.
Yes.
So this matter will be heard first, my lord?
No, Mr. Sain's matter will be heard first.
No, he is
Mr.
he is
Sen
to
has
be-
concluded. I am
Okay.
supposed to commence my arguments.
Mr. Sen has concluded.
Mr. Sen has concluded, yes. So let Mr. Surana's this matter, let that be heard first. If he finishes, then I'll commence my
Okay.
arguments.
Okay.
No
very well.
difficulty.
This matter will appear first. এটা আগে দেব। ঠিক আছে। Thursday.
Friday.
Kalyan Kumar Bhattacharya will appear Thursday. Thursday first matter. Second one.
আমরাও ভুল হতে পারি, তাও আপনি চেক করে নিন।